Let's call the meeting to order at 4:02, according to the clock on the wall. Please call roll.
This is the meeting of the Sunshine Ordinance Task Force for April 5th, 2017. On the call of the roll, Member Barnevsky absent. Member Eldon absent. Member Josh Wolf absent. Copra absent. Member Tesfa present. Member Moss present. Member Kanata
Here.
Kanata present. Member Fisher
Present.
present. Member Hinty
Present.
Hinty present. Vice Chair Highland
Present.
present. Chair Wolf
Present.
present. We have a quorum.
Thank you.
There are no agenda changes that I know of today. Would you like me to call the next item?
Any changes in the agenda, members? No? Seeing none? Okay, let's call first item.
Next on the agenda is item number 2, approval of minutes from the Sunshine Ordinance Task Force, March 1st, 2017 meeting.
Any changes, edits, adjustments, members? Seeing none? Public comment on the minutes? Seeing no public comment is closed. Can we take this by acclamation? Seeing no objections, it's passed by acclamation.
Next on the agenda, item number 3.
I recognize
File
Member
number-
Eldon at 4:05.
Yes. Item number 3, file number 16101, complaint filed by Michael Petrellis against Susie Loftus, Police Commission, for allegedly violating Administrative Code, Section 67.15D, by abridging or prohibiting public criticism of the policy, procedures, program, or services of the city or of any other aspects of its proposals or activities. On February 21st, 2017, the Education Outreach and Training Committee reviewed the complaint and referred it to the task force with a recommendation to find violation.
Okay, this came through the,
Education Outreach and Training Committee.
do we have anybody on that committee?
I was there. Who's the chair of that?
Josh Wolf is chair. Do you want to provide any background on this?
Yeah, I was looking through this today and trying to find, Victor, are the minutes for that meeting in a separate file someplace else? Because my question, I'll just ask you directly. It says we referred with a recommendation to find violations. Which violations were those?
I will read you an excerpt from the minutes.
Okay, which I couldn't
I
find,
believe-
so I apologize. Are those listed on our website?
Yes, they are.
No. Sorry about that. I thought Josh was going to be here.
All right.
It's the recommendation to find a violation of 67.15 by creating and or enforcing Police Commission Rule of Order 3.2 that abridges or prohibits public criticism of policy, procedures, or programs or services of the city or any other aspect of proposed activities. To provide a summary,
Yeah, that'd be good.
I believe
Well, let me ask you first, was this found to be in jurisdiction?
yes, it was.
Okay, so let's do that first. So let's get a motion for jurisdiction.
So moved.
Seconded.
Moved by Member Hensy, second by Member Eldon. Any discussion on jurisdiction? Any public comment on jurisdiction? Seeing none, can we take this by acclamation? Okay, so approved. Okay, continue.
Okay, I believe the committee opined that interruption of public comment is not a violation as long as the time is provided, full allotment of time is provided. However, the creation of the Police Commission's Rule 3.2, which states that a member of the public must address the commission as a whole and not individuals, that is the issue at stake, that they believe there's a violation by creating that Rule 3.2, which states that members of the public must address the entire body and not individuals.
Okay. All right, let's have the complainant first. You have 5 minutes.
Michael Petrellis. I've been going to the police commission meetings for a long time, and I've never really paid attention to how they have set their own guidelines regarding public comment that I believe infringe upon the First Amendment. They say, the rules say that members of the public can not utter words directly to specific members of the commission. At the September 7th meeting in 2016, I believe my comments were addressed to the then acting chief, and I had concerns about his educational qualifications. And I was interrupted by Susie Loftus, who was the chairwoman at the time, and said, "Oh, Mr. Petrellis, you have to keep your comments generalized. You can't be addressing a specific member." And for some reason, I didn't object. It wasn't until later that I thought, hey, you know, I should have been able to say what I want to say during public comment without interruption. And I wasn't given that chance. And that's why I filed this complaint. And it's, I believe, my second complaint related to a body that meets in City Hall that the Brown Act and Sunshine Act things apply toward, and they think nothing. The commissioners think nothing of interrupting public comment for different reasons. And I am trying to establish that members of the public can say whatever they want during public comment, whether you like it or not, whether you're naming a specific police commissioner or not. You should have the right, according to the First Amendment, to have your piece for the 2 or 3 minutes. And that's the basis of my complaint.
Okay. Are any witnesses or persons providing any additional facts or evidence on behalf of the complainant? Seeing none, the respondent, you have 5 minutes.
Good afternoon. My name is Rachel Kilsheim. I'm the Police Commission Secretary here for the Commission. Mr. Petrellis contends that during his public comment on agenda item at this...
Hold on.
I'm sorry.
The respondent is Susie Loftus. Is she here?
She is not. She's no longer with the Commission.
She works for the sheriff now. She resigned her post.
Okay.
Anytime there has been a complaint to the Sunshine Ordinance Task Force on behalf of the Commission, I attend.
I understand that, but it's not on behalf of the Commission. It's Susie Loftus. It's a person.
She's no longer with the Commission. She's not the Commission President, nor is she the Commissioner.
Through the chair, I think what he's trying to get at is, are you knowledgeable of this specific situation?
Yes.
Well, ma'am, let me
Well,
figure
I answered
out.
her question.
I know, but when the time is right, okay? Because the question comes to the chair, okay? The issue here is that this is about a specific person that made that was specifically named because they had made take certain action against the person. It's not about the Commission taking action. So I'm a little concerned that the actual person is not here, and I'm not quite sure how to proceed, because even though there's a person here who may be knowledgeable about the situation, this is not about just an agency or something that happened from a department. This is about a specific person, and generally the having somebody knowledgeable show up is usually with regards to public disclosure parts, not Brown Act or meeting parts. So before we move ahead, I just want to check in with our legal counsel and want to ask about process at this point when somebody is named and then they're no longer in that position, but they're still an employee of the city. Do they still have to appear? Because they're the ones that are alleged.
I think whether or not they have to appear, I mean, anyone who's named in a complaint doesn't have to appear. I think the only thing we should really be focusing on is whether or not we afforded them due process by giving them notice that they were named as a respondent to a complaint and that they had the opportunity to appear. We had done this before where former Supervisor David Chu had been named as a respondent. He left for state assembly, so we've no longer got jurisdiction over him. Whether or not we could still claim jurisdiction over former Commissioner Loftus because she's still employed by the city but with a different department, I'd have to look into that. But at this point, I think she may have still been a member of the commission and not appeared today, and we would have been able to move forward. I don't think there's any difference between that right now.
All right, so I think the best solution here is to find that the respondent themselves is absent and that we call for any witnesses or other persons providing additional facts or evidence. I think that's probably just for the record, just so we have the record correct.
Sure, yeah.
Okay,
all right, great.
So let's move ahead with that. So we'll note that the respondent, Susie Loftus, is not in attendance and that we are calling for any witnesses or additional persons to provide any facts or evidence on this. Proceed. Just restart the clock. Okay, thank you.
Okay. So then my name is Rachel Kilshaw. I'm the sergeant at the Police Commission. I'm here as a witness on behalf of the respondent, ex-Commissioner Susie Loftus. Mr. Petrellis contends that during his public comment on agenda item at the September 7, 2016 Commission meeting, Commission President Susie Loftus violated Section 67.15D of the Sunshine Ordinance, which prohibits abridging or prohibiting public criticism of the policy, procedures, programs, or services of the city or of any other aspects of its proposal or activities, or of the acts or admissions of the body on the basis that the performance of one or more public employees is implicated, or on the basis other than reasonable time constraints adopted in the regulations pursuant to subdivision C of this section. Rule 3.2 of the Commission Rules of Order, which, as explained later, is based on the Brown Act and Sunshine Ordinance, states that comments be directed to the Commission as a whole rather than to any individual. In relevant part, Rule 3.2 states members of the public should address their questions or remarks to the Commission. Neither police personnel, OCC personnel, nor commissioners are required to respond to questions except when requested to do so by the President. Individual commissioners and police personnel should refrain, however, from entering into any debates or discussion with speakers during public comment. When, during his public comment, Mr. Petrellis directly addressed Interim Chief of Police Chaplain, Commission President Loftus asked that he direct his comments to the Commission per Rule 3.2, and Mr. Petrellis went on to do just that. President Loftus restored 20 seconds of his time for him to complete his public comment to ensure that he received his full allotted amount of time and did not attempt to curb the content of his public comment. Thus, it is simply incorrect to say that Mr. Petrellis' criticism was abridged or prohibited. He received the full time to present his criticisms of the Interim Chief of Police, Tony Chaplin, among other issues. These facts are reflected in the full transcript of Mr. Petrellis' public comment, which are already submitted in the record. The right of public comment at meetings of the Police Commission and other boards and commission is prescribed in the Brown Act and Sunshine Ordinance. Under both laws, members of the public have the right to directly address the body, termed legislative body in the Brown Act, and the policy body in the Sunshine Ordinance, on any item on the agenda or that falls within the subject matter of the body. Members of the public do not have the right under either law to directly address the department head, in this case, Interim Chief of Police, or individual commissioners during public comment. The provisions of the Brown Act, Section 54954.3a, and the Sunshine Ordinance, Section 67.15a and b, clearly and repeatedly state that the right of public comment is the right to directly address a legislative body or policy body as a whole, not a right to address the department head or individual commissioners. What is equally important is that Rule 3.2 does not purport, nor has the Commission applied it, to curtail the content of public comment on any matter that falls under the jurisdiction of the Commission, including including criticisms of members of the police department, and that was the case here. After the chair reminded Mr. Petrellis that the rule required him to address the police commission rather than an individual, he did just that, making the same points to the commission that he started to make when he sought to directly address the chief. Rule 3.2 of the Police Commission Rules of Conduct state that public comment is to be addressed to the commission as a whole. 3.2 faithfully implements Brown Act and Sunshine Ordinance provisions to that effect. Further, in applying Rule 3.2 to Mr. Petrellis' public comment directed at interim chief of police, the commission president fully respected Mr. Petrellis' right of public comment. His public comment time was not reduced by the time it took to redirect his public comment to the commission, and the substance of his public comment was in no way censored. In sum, there is no basis here to conclude that 67.15D of the Sunshine Ordinance was violated. As a factual matter, there was no abridgment of Mr. Petrellis' right of public comment, and as a legal matter, compliance with a commission rule that implements the law set forth in both the Brown Act and the Sunshine Ordinance that public comment be directed to the body cannot itself be a violation of law. The Police Commission feels this complaint is without merit and should be dismissed. And I can submit this to you, Mr. Young, on behalf of the Commission.
Are there any other persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none. Members? Vice Chair Harlan.
Sergeant, could you approach, please? I just want to get to the heart of the matter, and you're claiming that this is drawn from both the Brown Act and Sunshine Ordinance. Reading your own 3.2, it's actually quite general, not nearly as specific as you just made it out. I'll read it to you. Members of the public should address their questions or remarks to the Commission. That's it. Not exclusively, not only to the Commission. So I just wanted to put that one out there for a start. And, you know, we have many meetings here where people respond to questions we ask them, different members of the Commission, the head of the task force. So that just doesn't sound right to me as, you know, general statements. I mean, you're referring to a certain statement made by a certain member or commissioner. You're providing context. Now, that commissioner doesn't have to respond, because that's up to the chair as to whether he would like to respond, or he can respond through the chair or the legal counsel through the chair. The chair is in charge of that commission, but certainly any comments from the public can and should be addressed within context. So I'd like you to show where in the Brown or SOTF that you're drawing that from.
Victor, I'm sorry, could I have that paper back? So the Brown Act states, and this is section 5495.3, every agenda for regular meetings shall provide an opportunity for members of the public to directly address the legislative body on any item of interest to the public. And I can keep going if you want. Before or during the legislative body's consideration of an item that is within the subject matter jurisdiction of the legislative body, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by subdivision B of section 54954.2. However, the agenda need not provide an opportunity for the members of the public, again, to address the legislative body on any item that has already been considered by a committee composed exclusively of members of the legislative body, and at a public meeting wherein all interested members of the public were afforded the opportunity to address the committee on the item before or during the committee's consideration on the item, unless the item has been substantially changed since the committee heard the item as determined by the legislative body.
Through the chair. Thank you. I think we're basically saying the same thing. Legislative body, committee, interchangeable. But it doesn't say that you can't address portions of that legislative body or individual committee members. That I'm not seeing. So that's something I think that we're probably going to discuss a little bit further. Thank you.
Member Eldon.
This is basically the issue that brought this up in front of the full body.
Okay. Sergeant, please don't leave. Thank you. So my first question is, were you at this meeting?
Yes.
Okay. How did Mr. Petrellis address the body that caused Ms. Loftus to stop his testimony?
I can read you the full transcript if you'd like. You have it, but he says,
Or
hello.
what specific part led her to stop him to?
I can only read, I can read for, I don't know why she did, but I can read to you at what point following Mr. Petrellis' comment she interrupted him.
Okay.
So he says to her, he says, hello, I'm Michael Petrellis. I'm here to address a number of issues, starting with Chief. I don't trust most of what comes out of your mouth. You know why? Because I recall in May when you accepted the interim position by a guy who was supposed to be the interim mayor, you said you weren't interested in the job. Now you're interested in the top job, okay? It seems like you've changed your mind. Correct me if I'm wrong about that. The other thing is, and this is where then President Loftus intervened, she says, Mr. Petrellis, you're aware of the rules better than anybody, and you can't actually address your comments to a particular commissioner or anybody up here. That's one of the rules.
Okay. Thank you. Don't leave yet.
Okay?
So I just want to, for the commission's benefit, I would just say that when presenting open government defense, that referring to your own bylaws when state law and the Sunshine Ordinance kind of overrides that, it's better to present it in context of those items. Now, you did mention it, you did read them, I hear that, but your initial presentation was to refer back to the commission's bylaws, and I have the same concern as our vice chair because it doesn't actually repeat it. So if the Sunshine Ordinance is actually, I would say, 85 to 90% a repetition of the Brown Act and the California Public Records Act. So having that in your bylaws actually makes it easier for us to accept a claim that it was in violation of your bylaws. Instead, it's just a lot easier to just refer back to the laws and not even pay attention to your bylaws, because now it's caused a red flag, and we'll probably ask that you, or at least I'll make a recommendation if there's an order of determination here. I'm going to make a recommendation to your commission that you revise your bylaws to reflect that. So that's my only point on that.
Just as a comment to that, if I may,
Yeah, sure.
These Commission Rules of Order dated August 11, 2005 were drafted, reviewed, and approved by the City Attorney's Office, just so you know.
That's fine, but we oversee
Yeah.
these rules, so.
Just wanted to let you know where they came from.
Right, but point taken, but at the same time, you're here and we have an issue with it.
Yeah.
So, to avoid in the future kind of thing. The other aspect is my question is did the chief feel that he needed to respond to Mr. Petrellis?
I don't know.
You know, okay, so he didn't try to make an attempt to
Not during his
answer or
public
anything
comment.
like that? Okay.
No.
Okay. Members, anything else? Okay, Mr. Petrellis, I just have a question for you.
I have a point of information.
Well, let me ask my question first.
Okay.
Okay. My question is for you, when you were making your comment, were you trying to, what was your intention in making the comment at the commission?
Questioning the acting chief's qualifications, especially related to his refusal to release grades, I think it was, or where he had received a degree. There had been a story, at least in the Chronicle, about where he had received his education and whether it was an online course or in person.
And after Ms. Loftus had interrupted you and then you continued, did you change your testimony in any way?
Yeah, I omitted his name.
Okay.
but still address the issue of a city employee, very important city employee, not being transparent about his education.
Okay.
Can I do my point of information?
Sure.
Okay, listening to you guys, reading the public comment rules, it doesn't say the police chief is included. My comments were addressed to the acting chief, not a commissioner, right? They're saying the rules don't allow members of the public to address a specific commissioner. The acting chief, and now the chief, Scott's his name, they're not members of the commission. The commission oversees the department, ostensibly, you know? So I'm saying, why did the chairwoman interrupt me at all when I wasn't criticizing a member of the commission?
Okay, thank you. Vice Chair Allen?
And just to be clear, this was during open public comment. I think that's what I read in the case notes. So it wasn't off topic. It was just open comment. Yeah.
Member Canado?
No, I mean, from what the respondent read, it seems like the issue was Mr. Petralis using the pronoun your, which is addressing the acting chief instead of just saying his qualifications. And to me, that's just a quibble, you know. So I don't see any issue with that.
Member Tesfaye?
It's the same thing. My question/comment was on the same issue because we were asking how he changed his public comment in response to the direction that was given to him, and he didn't use the person's name, but he definitely refers to him throughout as the current chief. So, anyway, it's the same concern.
All right. Do any other questions, comments? Do you have enough information? Should we move to rebuttals? Okay, let's move to rebuttals with the respondent. First, you have 3 minutes for rebuttal. No rebuttal. Complainant? Petitioner?
I think Susie Loftus had a duty to be here. And just because she's now at the Sheriff's Department is no reason why she couldn't have come up a few flights here in City Hall. She's working here in City Hall, I believe, and even if she weren't, she's working at other locations for the Sheriff's Office. She could have come to the committee meeting and to this meeting. And I think that she's been derelict about that. I also have to say that it's of concern to me. I mean, you guys know I'm tenacious, so it's a few months after September 7th. It's taken a good amount of time to get here, and I understand you are burdened with so many complaints. Like this afternoon, you're going to be hearing 3 or 4 complaints from the same complainant against the same agency, and she should combine her complaints into one, but that's another matter. I just wish that this had been acted upon sooner, because it's been a number of months. Thank you.
Okay, members, do we have a motion? Vice Chair Howland.
Well, I think the very first part about the abridgment and then the subsequent full allocation, I think we can probably all agree there was ultimately no violation there. And I like the direction you were going on, maybe an advisory letter about their internal, rules. I'm not sure I'm seeing it rise to a violation other than that, but just a point of clarification, perhaps us to them would suffice.
Member Eldon?
The reason it came here is because our reading of what the Brown Act and the Sunshine Ordinance says would allow Michael Petralis to use the acting chief's name, and he was told he couldn't, and he acted accordingly. So that's, in addition to an advisory letter to fix that, seemed like it was a violation to us.
Is there a motion?
I'll make a motion.
What is your motion?
To find a violation. Let me find the exact information. Give me a second.
I'll second.
So we're not doing 6715D. I think 16. Sorry, can you remind me of what we had in there? The exact number, Victor? I think we had. It wasn't an issue of completing his complaint. I think it was E, which was that he wasn't allowed. He was improperly limited from addressing the person.
Okay, but we need a section
Okay,
number.
let me.
Yeah, DCA caller.
Just a point of clarification. I think a point that Mr. Petrellis makes actually makes an argument against what he's trying to say. The acting captain is not a member of a legislative body, and everything in the Brown Act and everything in the Sunshine Ordinance regarding public comment addresses public comment addressed to that legislative body or to that policy body. That would be like allowing a public commenter to come up here and then directly address another member of the audience rather than you. I think that's the way to look at it. Now, if they're saying that they didn't award him enough time when they put him on pause to say you need to address us rather than address him, or if he's making the argument that they're saying that he couldn't even say the acting chief's name, I think that's fair. But to say that they interrupted him and said you need to address the policy body rather than addressing an individual who's not a part of that policy body, I don't know if you're going to find a way to find a violation there.
So the issue, it was D, sorry, 6715D, and the issue there is that they were essentially trying to abridge the public criticism that he was making related to the body and public employees because they didn't want him to use his name. So it was 6715D.
Okay. So moved by Member Eldon. Member Hinsey, did you second that?
Yeah.
Okay. Just go on.
Through the
comments.
chair, just comment on DCA Cola's comment there. I guess this really just goes to open public comment. Cannot one say anything one wants about anything? Does it have to be? It's as long as it's not on the agenda, they can say it. Like at the Board of Supervisors meeting, if you say something about the mayor, that's permissible, is it not?
Sure. Anything that's not on the agenda during general public comment, you can address to that policy body. But
or you can just.
I think you should clarify with the complainant whether or not he's making this complaint because he was told that he could not even reference the acting chief's name, or if he was told that he needed to address the policy body rather than addressing the acting chief directly. Because public comment during a public meeting is limited to you address that policy body. Was complainant addressing the policy body, or was he addressing the chief directly? Was he reprimanded or asked not to address the policy body rather than address the chief, or was he reprimanded for addressing or for just using the chief's name in general while he was addressing the policy body? That's the distinction I think you guys need to focus on right here.
So I want to just, if we can, kind of refocus what the actual complaint is, because that's really should be the focus, what we're talking about. I appreciate what DCA Cola is saying, and I agree with that. Looking back at Mr. Petrellis's initial petition for hearing was based on, and I quote, "I wish to lodge a complaint against Police Commission Chairwoman Susie Loftus for denying me my right to uninterrupted public comment at the September 7th, 2016 meeting." Okay, so with regards to the reason why he was interrupted is the subject of whether the ordinance was violated or not. But the focus of our decision-making starts with whether we agree that his public comment was interrupted. The reason why he was interrupted is really kind of secondary. Member Canado?
But the next sentence, basically, he's also saying that he believes that the commission's rules are in violation.
Right, and I think that based upon what Vice Chair Hyland was pointing out, it's really, they just are not complete. I mean, it just says that they should be, all comments should be directed at the policy body, at the commission, which is more or less, for being kind of short and brief, correct. Okay? The point that Mr. Petrellis is making is that he was interrupted incorrectly because the chairwoman had misinterpreted the public meeting laws because he was not addressing somebody directly, a commissioner. He was addressing a worker, a staffer, another person. So the question now is was the interruption correct or not correct? Doesn't matter who he was addressing at that point, as DCA Cola was had pointed out to us. Member?
And just a further note on how we thought about it in the subcommittee and how my motion was proposed is that the interruption is based on, it's not that he didn't have enough time or that they didn't give him time back on the clock. They gave him that back on the clock. It was purely the rationale and that shouldn't have been there. And it raises a larger issue about the police commission.
So then the question I have is subsection D the correct section for violation at that point? Because the abridgment, let's see, is that contains missions and base for
What else would you have in mind?
Well, hold on a second. I'm trying to find the point about abridgment here. Where I carried out. Oh, it is D. Okay, a policy body should not abridge or prohibit public criticism. And this falls under the list of items of whether it's policy, procedures, programs, activities, acts of omission on the basis that the performance of one or more public employees is implicated. So, I mean, he's well within his right to carry out that comment. The point here is he's making the claim that he was interrupted. The fact that he was given had the clock restart and whatnot, then becomes the question. If he was told to absolutely leave, like you couldn't have any more public comment, then you have it's very clear, it's clear cut, But just to be exacting, I'm not saying that you have to accept my thoughts on this, but just to be exacting, the question is that the question is he was asked to abridge his comment versus really being interrupted. He was interrupted and then asked to be abridged, so it kind of takes it one step further. Member Eldon.
So the issue there then is that, is it basically up to the complainant to realize that their rights were being misinterpreted to them?
That's why they're here.
by the commission. And so if the commission has a process that doesn't fit with what we believe is a correct interpretation, and they're giving him bad advice, and he's following that, and then realizes later that he followed bad advice and files a complaint, which is how I view this, then it seems entirely appropriate to use 6715D.
I agree. Okay.
I mean, but I know it's not perfect, but maybe if there's another thing that would fit this better, but it seems like that's
No, I think you're absolutely right. And I think the point is he was interrupted and then asked to abridge his comment. I think that's kind of the crux of it in my free association.
And for the abridging the comment, you mean by not using the specific name?
Right.
Okay.
Censoring,
Yeah.
basically.
Because reading what he stated, he did everything but say the name. He just said the title, but he did not get to say the name. So I just want to make sure that what my understanding of what you mean by abridging is the specific use of that person's name.
Right.
Okay.
Okay. Let's get public comment.
I just want to clarify
Yep.
the motion is a violation of 67.15D
For
for interrupting and abridging.
Okay, seeing no public comment. But you've, as being party to this, there's no public comment available. Okay.
Good afternoon. My name is Rania Adwan. I'm a policy advisor at the Police Commission. While I was not available for Mr. Petrellis' case, I have been privy to these before. It wasn't a matter of him using the chief's name. It was directing comment at someone on the dais. While Mr. Petrellis' transcript seems very polite. One of the reasons that they do this is because they try to hinder attacks, personal attacks, that do happen during public comment. So I just wanted to clarify that it wasn't necessarily the use of a name or not name. It was directing a comment at anyone on the dais.
So let me the dais does not protect anyone. What protects people is the law. And the law is specific that it's directed at the policy body. The policy body are the members of that policy body. The chief is not a member of the policy body. He actually should not be sitting up there. And
I appreciate that, and that's a completely different matter.
No, it's not a different matter. It's directly to the issue because
whether the chief sits up on the dais or not is not what is being discussed here. The question is whether or not Mr. Petrellis had the duty or the right to address the chief directly.
And we are claiming that he did.
I appreciate that, but that's not the discussion that you guys have been having. You guys have been talking about whether or not he used the chief's name, and so by not using the chief's name, whether it changed his statement.
Doesn't matter. He has the right to address a worker.
And he did. And he did. He didn't change his comments. He didn't change anything about it except to address the commission instead of one person.
But he was interrupted, and then he was asked to abridge his comments. And that is not allowed under the law.
Well, considering
for any public comment.
Considering this law was drafted by the city attorney, I'm quite confused as to how it's not allowed. No, the
law was not drafted by the city attorney. The law was drafted by the state legislature.
But our preamble is drafted by the city attorney.
No, it is not. For your rules don't apply here. What applies here is state law and the Sunshine Ordinance.
I just wanted to clarify. Yes.
Okay. No, I will call on him. Member Eldon.
Sorry. Yeah. So I mean, that was basically the issue. It's like you are correctly describing what the police commission rules are, and our rules. There's an existing conflict between the city attorney's interpretation of the Sunshine Ordinance on some issues and our interpretation, and it transcends this specific issue. But I think that is partly what's going on here. So you can say these things and be totally correct, but we can also be correct.
Thank you very much. Very informative. Okay, I will add to the motion that that we'll send an advice letter to the police.
Can we just include it in the order of determination?
In the order of determination, yes. They will send an advice letter regarding that they should revise their rules to coincide with the Sunshine Ordinance at minimum. Okay. Anything else for the good of the cause? Call the roll. Ready for it? Okay. You ready? Okay. Call the roll, please.
On the motion, Member Eldon.
Aye.
Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. Thank you very much.
It's my assumption that there is no referral to committee.
Okay. How about that we would like a reply that they've made in the adjustment.
Thank you.
Okay.
Next on the agenda, item number 4, file number 16113, complaint filed by Larry Chan against Lieutenant Catherine Whalen and the San Francisco Police Department for allegedly violating Administrative Code, Section 67.21, by failing to respond to a public works request in a timely and/or complete manner. This matter was heard on March 28, 2017 by the Complaint Committee and referred to the task force without a recommendation.
Okay. So, Complaint Committee have a recommendation for jurisdiction. Victor.
Oh, sorry.
Complaint Committee have a recommendation for jurisdiction.
We found jurisdiction on this item.
Would you like to make a motion?
I'd like to make a motion to find jurisdiction on item number 4. Larry Chan against Lieutenant Catherine Whalen and the San Francisco Police Department.
Second.
Moved by Member Tesfaye, second by Vice Chair Hyland. Any discussion on jurisdiction? Any public comment on jurisdiction? Seeing none, can we take this by acclamation? Seeing no objection. Okay. Proceed.
Is the respondent in the room? I can't see behind the rostrum. No one else is here? Okay.
How would you like to proceed? What is your recommendation, Chair?
I think we should proceed. Member Hinsey, sorry.
Member Hinsey. Frank, can you just move the microphone?
Oh, sorry. I think we can try to proceed and see. Yeah.
Okay. All right. Do you want to make a presentation?
Yes. Of course, we're going to hear from the petitioner, Mr. Chan, but something that I want you to focus on when listening to his statement, and something that we were having difficulty with, which is why there was no recommended violation of any kind. It wasn't because we didn't think there was a violation, but we thought that the full task force should deliberate on this issue of the status of investigations. Here, one of the main issues is that and he can correct me in his statement if he would like, but Mr. Chan had been investigated and reprimanded by the police department. He's an employee of the police department, and after he had received the decision, he wanted to appeal that. When he received the decision, he felt that the investigation had been closed and that he should be able to gather certain information from the file so that he could appeal the decision. In response, and subject to this petition here, is that the police department says now that he's appealed, the investigation is now reopened, and he cannot get the documents that he's requested. And so there just seems to be this back and forth on, when is an investigation open or closed. In addition to that, the police department said that whether the investigation was closed or open, they still would not release the records under certain sections of the evidence code. I asked them if there were any sections of the Sunshine Ordinance specifically that they could make reference to also allow them, as an exception for release of the documents, and they made reference to section 62.54. which I would like to draw your attention to. Which has to do with information where the disclosure would endanger the successful completion of an investigation, where the prospect of enforcement proceedings is concrete and definite. So they were able to make some references to the Sunshine Ordinance in addition to the investigation, in addition to the evidence code, as reasons why they should not have to turn over this information to Mr. Chan for him to continue to appeal the determination that had been held against him. And so that's just those are the kind of facts that we would like you to hear. At the last complaint committee meeting, Mr. Chan was present along with the police department, and that had been a continuation because we really wanted to hear facts. We were still, fact finding and trying to figure out from the respondent's perspective, why did they why do they consider the investigation still open, in addition to what other exceptions they felt they could use in order to withhold this information from Mr. Chan.
Okay, just a point of information. Was Lieutenant Whalen there at the complaint
She was
committee?
present in addition to, I believe, their attorney, Ms. Worsham.
Did she testify?
Yes.
Okay.
And I believe I thought she would be here today. She said she did not need to be at the police commission meeting, Lieutenant Whalen, and that she would be here today, so I don't know.
And there is no one here representing the police department in the audience?
I only see Mr. Chan.
Okay, then let's proceed, and we'll see what happens. Okay, petitioner, Mr. Chan, you have 5 minutes.
Good afternoon, Commissioners. My name is Larry Chan. I'm a police sergeant with the San Francisco Police Department, and the backstory of this is I am a elected union official at the San Francisco Police Officers Association. At the time this complaint occurred, December 21st, 2015, I had a Facebook group for just POA information as well as emails is how I disseminated information. I discovered some dirty tactics that the police department internal affairs were doing, violating police officers' rights. So on my off time, I made notice to the general membership, who are police officer members, that they were violating police officer rights on how they conducted their investigations out of San Francisco and showing up at people's houses. So somewhere along the way, the brass contacted me, told me to knock it off. Couldn't do that. They couldn't find a violation. Everything I had done was a First Amendment issue, as well as me acting as an elected union official. So I was sprung with an internal affairs investigation, which was investigated in the summer of 2016 and completed by September of 2016. They hemmed and hawed back and forth upon the decision and found. First, they were bringing me up on a violation of a social media policy, which they could not. So they went back and forth on a catch-all and created something of a violation. They tried to say I committed a crime, and they just did a catch-all and gave me a written reprimand, which the investigation was closed, and I had received a letter from the chief of police with the department wanting to impose a written reprimand. The process that works for Peace Officer Bill of Rights is that you can appeal the decision to a deputy chief who does a hearing for reprimands and anything lesser level for written stuff. Anything with days off or such can be appealed to the police commission. So I asked for an appeal, and based on my rights, I was able to receive all discovery from the investigator. Now, if the case had been open, I would be not entitled to any discovery. Had I not suffered a loss, being a written reprimand or higher, I would also not be available to any discovery whatsoever. So my goal was to see all the information to help me in my appeal. And then I noticed during the investigation from Internal Affairs, there was a memorandum written by a sergeant at IAD stating that she received an email with a screenshot photo of my union Facebook post, which she received, which was forwarded to her by an anonymous member on her SFGov email. Well, there was the red flag, which I asked for all of the emails that she received that day. because everything I received in the internal affairs packet, which you have copies of as well, because I'm an open book and I sent it all to the task force. I have nothing to hide. And I sent it all, and they asked for an extension, gave me, after 14 days, I received 44 emails, 5 of which I questioned. There's a lot of redactions, which I understand, with names and phone numbers of citizens and critical flyers, but the 5 I had asked for were completely blacked out. And back and forth, the legal division had kept telling me that, oh, okay, it's not, you don't get that because it's 6254K. First, they claimed it was a witness protection. Then they went back to the evidence code. Then they went back to an ongoing investigation. The department could not decide which one to hold part of the government code. I also stated in the last meeting there was an appellate court ruling for California City of San Jose versus Santa Clara Superior Court. Anything used on personal email for work purposes is now part of public record, which I found out later from attorney Stephen Betts, the other IA attorney, and I have the email, which is attached to the files as well, that he said he spoke to Sergeant Riley, and she stated that she received it, the screenshots on her personal email, which she then forwarded to her work email and printed it out. Now, 5 pages are there. I want to know what's written on there, because if there's things on there that you're thinking, they're saying it's confidential or another case, then that can be redacted. But how do I know there is not collusion between the city and the deputy chiefs to silence me on my First Amendment right to notify membership as well as the police department of dirty taxes by the police department? That's pretty much what this is in a nutshell.
Okay, thank you.
Thank you.
Are there any persons or witnesses on behalf of the petitioner or complainant provide any facts, additional facts or evidence? Seeing none, respondent. Respondent is not present. Any persons or witnesses on behalf of the respondent provide any facts or evidence? Seeing none. Task force members. Member Eldon.
Well, I was going to ask about jurisdiction.
We already did jurisdiction.
So this is, could someone walk me through did I just miss that?
Yeah, she did like a 5-minute expose. Okay. So it's more or less what the complainant had presented, that he was brought up on charges, was given a written reprimand for posting information that was related to his workplace on his off time, off duty, not on city networks or
yeah, sorry, I
services and whatnot.
misunderstood what the context was.
Okay,
when you were
great.
talking about that.
Okay, great. Vice Chair Howland.
Quick question. I know the San Jose thing has come forward. Is that retroactive? Maybe people are more up on that than I am.
I think that's, do you have an answer?
Well, I mean, I've been working through that case at work, and the records are still on her phone. They're still there, so the case would still apply.
Yeah. And the second piece is it was forwarded to a work account for printing, and we're still within the 2 years records retention window, I believe. Right?
Mm-hmm.
Well, and the fact that if the case was closed, okay, and 2 years passed by, and then the retention would apply. But if they are going to consider the case was reopened, then it's still open. There's the retention continues.
Right. I know we've had cases similar to this, not this dramatic, but cases similar to this, as far as what the police redact and don't redact, to protect victims and whatnot. I don't see this being that, but in each case, we've had to have someone from the Police Commission come up and specifically tell us why, per which code, each line is redactable, and we've ruled on that. So it would be nice to have a blanket policy from us saying, but I think it's case by case.
Well, actually, the complainant's petition for hearing is specific to emails that are redacted. So we would like to know, first of all, what code they are following to allow the redaction, And then we have to determine whether the information's being redacted actually falls under that. You can't just state, it's like going back to that rule of reason kind of thing. You just can't state it and not provide any reason for it. Yeah.
So that was something that we were concerned about, which is why we had continued this to our most recent meeting, because we wanted the police, the internal affairs branch, to be present for us to be able to ask those kinds of questions. And the response that we received was that they made reference to Section 6254K. They also made reference to the Sunshine Ordinance, Section 67.24, and saying that this is this is exempted or prohibited pursuant to state or federal law, including but not limited to the evidence code relating to privilege, because this was an open investigation, that this investigation had been reopened because he had appealed it.
So let me...
And that there included information there about witnesses that had provided information against Mr. Chan.
Okay, so let's go with the information that you have first. Let's kind of tear through that a little bit, okay? So they've given you some actual government code to state why they redacted the item.
As well as some details on what the contents were of the item that was redacted.
What were those details?
They said that there was information there about witnesses who had participated in the investigation against Mr. Chan.
Okay. And did they give you a reason why they reopened the case?
It was reopened because he appealed it. So that's why. It's kind of circuitous because it was closed because they made a determination. Mr. Chan wanted to appeal the determination, so then it was reopened. I asked if there was a specific written policy or anything like that in place that it gave people an expectation as to when investigations were closed or opened. They did not have that.
Okay. Hold on a second. I need to write something down for this. Okay, who's next? Let me just ask DC Acola a question. Are you aware of any, in your research for this case at all, or are you just aware of any code that allows for a case like this at under a law enforcement agency to reopen a case once it's been closed in this respect?
I think any agency is within their right to reopen a case if they feel they have reason to do so. And I don't think that depends upon.
That kind of asks, so if there's no specificity, I'm really looking for specificity.
There's nothing in any that I've seen in any public records related case law that indicates that an agency is forbidden from reopening a case.
Okay.
Now, I mean, if evidence were to come forward that they reopen the case for the sole purpose of asserting an exemption, that's another thing. But
okay. All right. Thanks.
And they said any case that is appealed is reopened.
That's what they were saying. Any case so it sounds like there's a rule somewhere.
It is, but I asked where that was written, and they said that it wasn't written anywhere.
Okay.
Do the chair?
Yeah.
I mean, if a case is appealed I would think that there's got to be some other sort of administrative discovery process that will allow access to those documents other than Sunshine. And I'm not sure if maybe you want to ask the complainant if he tried by other means other than Sunshine to get these documents. Because there is the issue in the analysis that I did for the case law that was available. As to the issue of records that are disclosed pursuant to Sunshine and maybe were questionable as to whether or not they were public records, now are become public records for any other requester. So there's that issue that makes it maybe more feasible to, obtain the documents via some other method.
Got it.
If possible.
Got it. Thank you. Mr. Chan, would you like to answer that question?
So I've been in the police department over 23 years, and the way the investigations work is once the Internal Affairs completes their investigation, the investigator gets it signed off by the OIC, the officer in charge, and then it's hand carried to well, back then it was just the administrative deputy chief. Now we have 1 million chiefs. So it goes to the chief of staff, and they sign off on it for the chief of police for a letterhead to impose discipline. Now, it's considered an open case if you do not accept the discipline. There is no further investigation. They have moved on. That file is essentially closed.
And is that what happened with you?
This is what's going on.
Okay.
That's how the police department discipline process works.
Okay.
But you did not accept the discipline, right?
Correct. If you say, no, I don't want to take it, I don't want to fight it, then it goes, it
To the
just
next
remains
process.
open.
Right.
It just considered remain open, and they can't close the case completely, but no further investigation is done. It's not like a rebooking packet in the court of law where the district attorney would not find insufficient evidence, would code it, code 27, and need more investigation, and that individual is released, and the charges were dropped in interest of justice. That's not the case with this. They are done. They answered you, the city answered you with a semantic of yes, it's considered open, not whether the investigation was closed. I can guarantee you it is closed. There's no new evidence, but like I stated before.
Are there any new charges against you, or
No.
did somebody try to amend the charges?
No, they cannot do that by way of 3304 of the government code.
Okay.
There's due process. They had a year to finish this thing, so over in a year.
Okay.
So me not accepting the discipline keeps it open. And Chair Baranetsky had asked the last meeting, or 2 meetings ago, what was the timeline, and then I was served with the chief's hearing. And like I said, I could have dragged it on for a year or requested it to be pushed forward. But anything that would happen, that's why I was trying to find more information when I called the Internal Affairs lawyer. He goes, well, you received everything in the investigation, transcripts, there's everything. There's a photo of myself in there, the memorandum, but then I caught discrepancies and I caught inaccuracies from the attorney and from what the investigator had generated the complaint, which was not true. So that's why I'm like, well, how come I don't have the email? I have the memorandum, which is a lie. Well, she said this. I'm like, well, it doesn't matter what she put it on a city document, which could harm me. And that questions transparency, and you're not on the up and up. I mean, you gave me everything but that email, and those are the 5 pages. When I had questioned the 5 pages, I'm like, I even went to the point of, okay, just redact. If it's from a personal email, redact the email. I just need to see the body of what's written in there, because if there's 3 pages of an attachment, there's 5 pages blacked out.
Do you mean redact the email address?
Correct, or names. If you're trying to claim witness protection, but there was no crime that had been committed here.
Okay.
This is all administrative.
So have you followed any other channels to try and get this information other than through?
No,
the
I
Sunshine
started with
Ordinance?
this being a taxpayer and city county resident in native San Francisco. This was my first start.
Okay.
And like I said, this was everything I had written was hyperbole. I'm just fighting to maintain my personnel record and to stop them from a collusion of shutting me up, pretty much. They didn't like what I was saying because they had a policy that was not written where they're showing up at people's houses without due process. And they didn't like me fronting out their sneaky ways of doing it. So sorry if I was the guy that was essentially being the whistleblower. And I think there's something more in there because they're trying really hard not to release it. Had it been another officer or someone of the same rank as myself, they probably would have gave it up in a heartbeat.
Have you thought about that? A whistleblower complaint?
Yeah, but there was no written policy. This came out during the Internal Affairs interview. There was no written policy on this because they were doing pretty much like a Los Angeles Police Department shady tactics thing.
Yeah, okay.
And they're violating a lot of policies that I could get in all day about this
Okay,
thing. So.
okay. We have some other questions. Did you, Frank, did you? Okay. Chair, member testify.
Oh, no, I'm okay.
You're okay?
Yes.
Okay. Anybody else? Okay. So let me thank you.
Okay, I got one more thing to add.
Question.
Sorry?
I have one more thing to add that everything I've given you, I'm an open book. You can look through my personnel jacket. So that's why I sent everything there. Everyone
Okay.
can see it. It was open to the press. You can have at it and ask me questions.
Thank you. Sure.
I did have
Member
another
Moss.
question. I'm sorry.
Go ahead.
Sorry. So if we were to find in your favor on this, would this have ramifications for other police union members that who are subject to investigations? Like what? I mean, this is not necessarily something that is going to be limited to your case.
Well, it depends how the information was obtained to harm a member. Now, no one has ever tried this. I just thought about it because, I mean, you always think of ways to defend yourself to clear your name. And that's how I felt that I could start by this because, I mean, I caught an error there. That was it. There was an error in an investigation that I caught. And there's emails. As Willie Brown said before, emails, E stands for evidence, and that shows up on everything. And they messed up by responding to me by saying one thing that was written on the document that could harm me. So it could open the door for other things if only if they had used the city email system and their whatever avenues they tried to harm a member. And I'm not saying that's going to get everybody off. Some people, are recidivists or there are bad cops, there are good cops, but First Amendment issues are totally different. And for the upper echelon to try to shut up a member for exposing their dirty tactics, I think that speaks a lot. And I was just the one to say something about it.
And if it was not you up here, but say it was Mr. Petralis over here who was filing the same request, you'd be okay with him filing this request for a file that reveals things in your Facebook page?
Well, my Facebook page was a private Facebook page.
But nevertheless.
Correct. I mean, it's a public record.
With somebody asking for it to be your public, your private Facebook page that was submitted in an investigation to be made public.
Correct.
Through this process, you'd be okay with that?
Because that Facebook page is now deleted because I had it was just another avenue because I had to start with the social media thing. I used to just send emails out. It was easier than making copies and sticking in people's mailboxes throughout the department because I had the entire department other than just one station. So social media was a way for people to get information regarding union issues and city issues. So, and the only other reason was that they could comment on it and vent, but it was private. You had to be invited. And I brought that up when they interviewed me. Like, hey, you have captains, lieutenants, deputy chiefs on this, so you want to open the Pandora's box, let's open the Pandora's box, because everybody knew about it. But it took for one person that didn't like what I was telling them, probably someone that was involved in administration, to front out dirty tactics that started this complaint.
I don't think you answered. I don't think you answered Member Moss's question, but to comment on it, what he's asking you is if someone else had asked for these documents about your Facebook page, not about your Facebook page being private, but that these emails were the basis for a memo that ended up as part of your determination.
Correct.
And so it's not about the Facebook page being private or not, it's about the email addresses containing information, in this case a screenshot of a Facebook page, comments on the screenshot of a Facebook page that were the basis of this memo. That you are saying had inaccurate information. So it's not about the page being private or not. It's would you be comfortable with someone else using the Sunshine Ordinance in order to get this information about you?
No, I have no problem with that.
That's what I figured your answer would be, but that it's just not about it being the page being private or existing anymore. It's about it being used as the basis for this memo.
Yeah. Well, the basis of the memo was their memo was inaccurate from how she obtained the information.
Right, but you don't have that information,
But yeah, I mean, only reason why I made it private because everyone has their own camps and their own representatives. Somebody, well, you get the person you trust. These are the people that
and it doesn't matter that it was private. It's just that information was in an email.
Correct. And I was not trying to hide anything. It was dissemination of information to the membership.
Sure.
I'd like to ask just one last question.
Go ahead.
Does this intersect with the Public Safety Officer's Bill of Rights at any? I mean, somebody who knows your rights as a union, member.
In regards to how the information was obtained.
I mean, is this information protected in that regard, or is this information something that would have had to have your sign off before being added to a file?
No, I kind of don't understand the question.
I don't necessarily understand the peace officers, Bill of Rights myself, but I do know that it offers a lot of protections for public safety officers to not have information related to their personnel files released.
Well, like anything adverse impact that would go before it would go in your personnel file, you would have to be notified of it. You'd have to sign for it, and you would have to agree to it. Yeah, if they investigate you for any reason whatsoever, they have a year to. The Internal Affairs or the department has a year to complete the investigation, and then discipline can wrangle on longer than that, because once the investigation's over, the part about the discipline can be negotiated or fought or appealed. But as far as your rights for anything that goes to your jacket has to be approved, has to be agreed upon by the member or imposed by a larger body like the police commission next door.
Vice Chair Hyland.
This actually reminds me of a whistleblower case that we did here, where a whistleblower came before us and didn't want any protection, wanted all the files released and open to show what had happened. But I think the whistleblower, I guess the city whistleblower department, whatever, had reason to not release it because it indicted several city departments. And this kind of smacks of that, i.e., it smells of fish to me. I would move to find a violation. I would also move to find a violation of failure to send a knowledgeable person.
Right, hold on, let's finish the process. You might hear some other things.
Yeah, that's just where I'm getting to,
Yeah.
on this so far. Because it would have been very useful to have Captain Whalen here to give us an idea of their stance and their position.
Right. Gotcha. Anybody else? Okay, so let's move to rebuttals. Since the respondent is not here, Sergeant Chan, you can have 3 minutes if you have any additional comments or rebuttals about what we were talking about here.
I have nothing else to add. I mean, just the mere, they fight it, the department fights it, and they come back and they didn't send the one attorney, they sent Ms. Worsham, who didn't completely answer the questions correctly, but they don't come today, which is the final, which I don't understand. So it still leads me to believe that they're withholding something, and who else are they trying to protect? I mean, I think you can even review it before if you approve that I see it, to determine if I should see it or not. But, I mean, it questions what are they trying to hide. I mean, everything else is redacted that should be redacted, but everything else there is blacked out. So it just leads to question what is going on in 5 pages that you couldn't release to me, period. I mean, you couldn't put it in your memorandum when you generated the complaint.
Okay, great. All right, motion. Member Eldon, in the microphone.
This is just real quick for context. It occurred to me while you're talking, sir. Can you, since most of us here don't have a lot of context about the inner workings of the SFPD,
okay,
how common is this sort of issue with, from a union member and leader perspective? Is this incredibly rare, and so you're like, I got to jump on this, or are you like, I'm tired of this happening all the time, I'm taking one for the team?
This is rare because, well, if you had asked Commissioner or Police Commission Secretary Sergeant Kilshaw, and if you ask about my name, I'm kind of the guy that's very revolutionary and that will speak my mind, and much to my demise sometimes, but I will stand up for what is right. So for me, I have nothing to lose. I'm not going anywhere, but I'm not a guy that's a recidivist that you'll see next door as well. But I will question when something's wrong, and I think I have a lot of respect in this department. So this thing here is just unheard of. I mean, I think I only know of 2 other people that have brought this up to the Sunshine Ordinance Task Force that are police officers, and that probably only had something to do with testing or something to that effect, but nothing in regards to personal matters, because nothing came up in an email where they messed up and used their work email to generate it. So that's their fault for not being the good investigator they're supposed to be. So that's how I look at it. I saw a loophole. I saw that, and I used it against them like they were doing it against me. I mean, it's just a game right now.
Sure. So, and I hope it's not to your demise, but just to your detriment.
Well, working for this city for all those years, it probably is like a demise.
All right. That's what I was saying. I hope it's not about his demise. All right, motion. Is there a motion? All right, what? Somebody, clock is ticking. Come on.
Past 5 o'clock.
Yeah. In the notes.
Okay, so I'll make a motion to find violation on 67.26, withholding kept to a minimum, and 67.27, justification of withholding, not justifying.
Yeah.
In the microphone. Yes, you can speak through the chair freely.
All right. So, not 21, the timeliness?
Timely or complete? Here would be complete.
Yes, you didn't like timely and/or complete?
That's fine, too.
Okay, well, I wasn't going for 26 or 27, so now we've got things that...
I mean, I have a problem where they, in most of the documents, the redaction looked reasonable. They had either a name redacted or
Yeah.
people's phone numbers, and you have 5 pages that are totally black. And even though in the packet they're applying the code, there's no explanation for
Yeah, I didn't like the 5
why
black.
that code applies.
All right.
So that's why I was going for 27.
Well, I would proffer that they did give reason why it was redacted. They gave some government code sections, whatnot, but they didn't prove that it was applicable. And so, I mean, this is somewhat of an issue because we don't have the authority to see things in camera. And so, actually, that's a subject I think we should discuss because we can ask for permission for that. Or we can try to make arrangements for somebody who has the authority to see things in camera, like a judge, or some other body that has similar authority to do so. So
Like a third party.
yeah, yeah. So okay, so we have 67, 21, 26, and 27.
No, I'm backing off at 21.
You're backing off 21.
Yeah.
So not 21. Well, then let's make a motion, and then we can make amendments.
All right, so I
Instead of
have
going
motions
around
out there to find violation on 67.26 and 67.27.
And can we add 62A, failure to send someone knowledgeable? 6722A.
Sure. Whatever you like.
I'd like to. I have to ask him, I guess.
All right. Wait, the maker is deciding whether he wants to accept that suggestion.
Yeah, I'll definitely accept that.
Okay.
They were just here. They could have stayed.
Oh, there was different people.
No, different people.
Still, they're next door. They could come over
Yeah.
anyway.
Okay, is there a second?
I'll second.
Okay, so,
No, please send some stuff.
okay, so moved by member Kanata, second by member Tesfaye. All right, any further discussion on the merits of the motion? Public comment on the motion?
Hello, Michael Petrellis again. First of all, I'm really glad this guy, Larry, has filed this complaint. I think it is a terrific matter for you to take up, and it sounds like it would, if he succeeds in getting everything that he wants from the police department, it's going to greatly expand sunshine and accountability, especially over the police department. And I want to strongly complain that the police department didn't send anyone. I think that I think sunshine is a requirement that each department has to see sunshine as part of their required duties, and when a complaint is filed, they have to send a knowledgeable representative to the committees of the Sunshine Task Force and also the full task force meetings such as today. The fact that no one has shown up here that they think it's discretionary in terms of answering this complaint is really disturbing. And I hope we soon get to general public comment. Thank you.
Right after this. Okay, anything else for the good of the cause? Should we move to a vote? Please call the roll.
On the motion, Wolf absent, Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Highland.
Aye.
Highland, aye. Member Eldon.
Aye.
Eldon, aye. Barnetsky, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, let's call for general public comment.
Any follow-up on this
Oh,
matter?
yes. Let's see here. Well, I guess because this, problem is that because it's not under 6721, we can't order the documents to be produced. So, no. There's no compliance. There's no compliance or anything like that. The only provision of authority or enforcement that we have under the open public disclosure is under 6721.
Can I suggest a new motion then?
You can make an additional motion.
An additional motion. Find a
just make a
violation
motion.
under 6021. Was it A? I mean, I want to give us the power to be able to keep this moving.
Let's see here, 67. Let's make sure I got the right guy here. 721. I think it'll be under E. Yes, 6721E. Upon the determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. If the custodian refuses or fails to comply with such an order within 5 days, the Sunshine Task Force shall notify the district attorney or attorney general, who may take whatever measures she or he deems necessary to ensure compliance with the provisions of the ordinance.
Okay. So a motion under 6721E to find violation.
Okay. And within the motion, let's put what the order is, because it's the order of the task force, not the order from the chair, external of the motion.
To produce the 5 completely redacted pages. Is that what if you want to be specific? And that's the heart of the matter, right?
Yes, is that correct?
Mm-hmm.
Okay. All right. 6721E, 5 redacted. All right. Let me wordsmith this a little bit. I would say that to produce the reason for citing the to provide proof or evidence that supports their citing the codes that allows them to redact. You follow me?
Let me try and clean that up. What I was going to say is, I'm looking for the specific.
Let me get member testify.
Go ahead.
During the complaint committee hearing, they said that there was information in those 5 pages that pertained to witnesses in this investigation. And that's why it was redacted. And so they did give a reason. It's so, we haven't reviewed the document in camera. We don't know exactly what that is. We don't know if maybe the redaction could have been done, as Member Kanata mentioned, maybe in a more detailed and specific way so that you have the contents of the email, but not the names, addresses, other identifying information, rather than blacking out the whole page. So they did. I don't know if they deserve another opportunity to say what they have already said, that this pertains to witnesses.
Well, the other thing I would add is nobody here is under oath. I'm not saying anybody's lying, but people can say whatever they want, and
Okay.
it doesn't necessarily have to, obey any law with regards
So
to
let me
that.
rephrase that. So 6721E, and specifically, we're asking the SFPD provide pages 10 to 15 from their December 9th communication with limited redactions and show the body of those pages without any references to names, emails, phone numbers, addresses, just purely the body of the emails.
How about just state what you would like to see redacted? Like what you are considering to be redacted without any conditions. So with just redactions of personal names.
Personal names, phone numbers, addresses, email addresses.
And identifying information.
Identifying information, thank you. And provide the body of those emails.
Okay. All right, does that sound okay to everybody? Is this, Member Eldon?
Procedurally, just looking at the rest of what he says, this means that it could involve the city attorney to help the enforcement of this, based if we decide on this.
It will. I mean, in my experience, they're going to say the city attorney advises us that we're within our, and it's going to keep on going, but at least we have to hold their feet to the fire and get them to explain why they feel they can redact entire pages.
Okay.
So for very
So
specific.
city attorney and district attorney in different parts of it, so I wasn't really sure what the.
Well,
how it all
the
worked.
part is if they refuse, then the task force has the opportunity to refer this to the district attorney or his boss, the attorney general.
Okay.
Okay?
I don't believe that's an additional violation. It's more of a pursuant to 67.21E. We're requesting that to provide the information within 5 days.
No, actually, I would state that there is a violation of 6721E for not providing the information that the requester had asked for. It was not complete.
And it will be referred
I will
to
refer to compliance and amendments.
with the request to produce the document with limited redaction or provide detailed reasons why certain sections are redacted.
No, we have to be stronger than that. So with redact any identifying information, but include all other body contents.
Yeah, the redaction is specifically to personal
To identifying
information.
Yes.
Right, everything else you want to see. Let them argue back that this particular passage cannot be revealed for a specific purpose. Let them do that. But as far as we're concerned, the entire document is public, should be made available. If they want to claim that there are certain provisions that allows them to redact, let them argue what those are. But redacting an entire whole 5 sections of pages without adequate reason is not sufficient for the task force. Okay? Anything else? All right, so moved by Vice Chair Hyland, second by Member Kanata. Public comment. Seeing no public comment, we ready for a vote? Please call roll.
On the motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. The motion passes.
You didn't ask for mine.
Oh. Sorry. Chair Wolf.
Aye.
Wolf, aye.
Item is approved. Okay, let's go for public comment, general public comment at this time, and then we'll take a short break after that.
Did you give instructions for committee or?
Yes, I did. It's in the motion. Thank you.
Missed that.
No problem.
Hi, Michael Petrellis again. I'm going to repeat myself and thank all of you for serving on this important commission. You put in hours of your time just at the hearings, and then I'm sure hours of more time reading all the documents and familiarizing yourselves with all the sunshine laws. So thank you very much for what you're doing, because you're serving democracy, and it's very important to have this body that other municipalities don't have. This body performs an important function in holding our government accountable. The other thing I want to repeat is that these meetings need to be aired on government TV. It is a shame that this room is not wired for cable, and I want to find the time to keep going to the Rules Committee to urge them to find the money in the budget to put these meetings on TV. I think that the general public and government employees would learn a lot if they were able to watch these hearings. They could learn a lot about what went on with public comment and having good public comment rules at the police commission. This fella, Larry Chan, again, I think the public and the police department would learn a lot if they had been able to tune in to hear and watch what he had to say, and then hear and watch what you all were questioning him about. Last two items, I'm filing lots of FOIAs with the Trump White House, and I'm trying to get on their, I guess, enemies list. They don't like people who are filing FOIAs with them. Not getting any responses, but I'm still putting it out there on the web. I am getting responses from a number of federal agencies in terms of their FOIA logs and pay stubs for everyone in the White House and at the Vice President's office. So it's just good to be part of a loose network nationally that's filing FOIAs with the federal agencies. And finally, I have to acknowledge, I saw Nicholas in the mission recently and had a friendly conversation with him, and
I saw you in the mission.
He complimented, this guy, Nick, he complimented me on my piñata and giving Trump a hard time with my piñata on the New York Times webpage. And I've also seen Lou Fisher in the mission. So I just want to get it into the public record. I see some of you outside of City Hall, and I don't know why I find it so funny, but thank you.
Any other public comment? Okay, seeing no public comment is closed. We will take a recess for, 10 minutes? Is that all right? Yeah. Okay, we'll be back at 5:50. Okay, it's call meeting back to order at 5:59. So we're a little over here.
Sorry.
Thank you.
Next on the agenda.
Go ahead.
Item number 6, file number 16083, complaint filed by Andrew Will against Kate Patterson and the Arts Commission for allegedly violating Administrative Code Section 67.2 by failing to respond to a media disclosure request in a complete manner. On February 28, 2017, the Complaint Committee reviewed the complaint and referred it to the task force with a recommendation to find violation. I believe that is incorrect. I believe it's a recommendation to find no violation. Yes. Yes, that is a misstatement on the agenda. It should be a recommendation to find no violation.
Okay. Complaint committee jurisdiction recommendation?
We recommended that we find jurisdiction on this item, given that the Arts Commission is an agency of the city.
I'd like to make a motion.
I'd like to make a motion to find jurisdiction on item 6.
Second.
Moved by Member Tesfaye, second by Member Fisher. Any public comment? Any comments, members? Seeing none, can we take this by acclamation? Seeing no objections, motion is approved. Complaint Committee, Priso.
I mean, if possible, if we could just jump in with what with what the respondent has to explain. In this case, the request had been for all documents, police reports, inter-office emails, and photographic evidence concerning a statement that was made by Ms. Patterson in a letter dated August 31st to the Sunshine Ordinance Task Force, to a letter that she sent to us about having a history of contacting commissioners via emails, showing up at their residences and workplaces. And I believe those documents were the ones, they did not exist to be turned over to Ms. Trudeau. And that was all the information that we really had.
Okay. No, we're going to go through a process, and then I'll have you come up. You can just stand there for a moment. Okay. Anything else you want us to know at this point? Okay. All right. So we have been notified that the complainant petitioner will not be present tonight for this item and possibly others. But are there any persons or witnesses to provide any additional facts or evidence on behalf of the petitioner complainant? Okay, seeing none. Respondent, you have 5 minutes.
Sure. I just simply wanted to clarify one thing, that we do have substantial evidence that supports the statement that was made that she does have a history of harassing both staff and commissioners. And so it wasn't that I didn't have those records. I did have them, but we have established on multiple occasions, both here and at the Ethics Commission, that we're not going to turn those documents over because they expose the identities of people who have complained to the Arts Commission about certain behavior that Ms. Trabue or Ms. Datesh have, that she has, shown up at their work, all the things that you just mentioned, and that we don't want to exacerbate any kind of harassment by exposing the identities of those who've come forward. So we've withheld those documents, and we provided the legal justification citing the whistleblower laws and the California Evidence Code. And so I did withhold those documents and provided that information. And so,
Can I ask a question? I thought you said that you didn't have any police records. At least that's what I saw in the packet.
No, I didn't.
Hold, let's just have her 5 minutes, and then we're going to ask for witnesses and then we'll get into the question and answer.
No, that's okay. So I did provide for you the police records that we do have, which include a restraining order that Commissioner Barbara Sklar had against or for protection from Ms. Trabue or her, whatever, I think her name is really Paula Datesh. And so that's the only police record we have, and that has been turned over to Ms. Trabue multiple occasions, and she presumably already has it because she was involved in that case. So I provided, I think, a very comprehensive history of all the times that we've been before this body on the same issue. She continues to request these documents, and we will continue to deny that request. And so, again, I just want to clarify that we do have substantial records that support the statement that was made that there is a history of harassment by Ms. Trabue against both the Arts Commission staff and Arts Commissioners and other members in the Street Artist Licensing Program. And, our position is that we want to protect those individuals from further harassment, so we are not turning over anything that may reveal their identity. I'm also want to just share with you sort of, again, to back this up, I think this is an important document. It is a letter from that's related to a recent Board of Appeals case. Ms. Trabue was denied a street artist license. And this really, again, outlines her history with the Arts Commission and a number of, I think, disturbing incidents. And I have this here for you. But again, I think this falls in line with again, sort of this history of harassment and that we've experienced at the Arts Commission. So I have that here, Victor, if you want to share it. It's, it's public records.
Is that it?
That's it.
Okay. Any persons or witnesses on behalf of the respondent provide any additional facts or evidence? Okay. Seeing none, member testify.
I was just making reference, I can give you the page in the packet, where there was a paragraph in your letter where it says, this is from Ms. Trudeau, where she said that she did not have the police records in her possession, but that you said that they were already in her possession?
Yes, a copy of the restraining order, which I provided to her on numerous occasions.
Okay.
That's the only police record the Arts Commission has.
Okay, thank you.
Did you provide the complaint committee with the citations of law that allow you to withhold the information?
I did. It was included in my letter and in my response to her.
Okay, hold on.
I can tell you now, they are the California Government Code 6254K. So in my response to her, I said the Public Record Act protects from disclosure, quote, records the disclosure of which is exempted from prohibited pursuant to federal or state law, including but not limited to provisions of the Evidence Code relating to privilege, unquote, California Government Code 6254K. Two such provisions are the identity of informer privilege, California Evidence Code 1041, and the official information privilege, California Evidence Code 1040. The Act cross-references these Evidence Code sections in its listing of more than 500 California statutes that protect records from disclosure, California Government Code 6276.32. The Sunshine Ordinance does not specifically preclude the city from relying on the identity of informer and official information privileges as grounds to disclose a record in response to a public records request. The city attorney's Good Government Guide, which explains open government rules that city officials and employees must follow, and which is available on the city attorney's website, blah, blah, blah. In some circumstances, departments may shield from disclosure the identity of a person complaining to the city about violations of law, California Evidence Code 1041. Privacy or other grounds may also authorize or require non-disclosure even where the complainant does not allege a violation of law, California Government Code 6254C. Substantial public interests often warrant withholding the identity of complainants when, for example, a tenant complains about a landlord, a neighbor complains about a neighbor, an employee complains about an employer, or a citizen complains about a person making public disturbance. Disclosure of the identity of the complainant and or the investigation could lead to retaliation against or harassment of the complainant and could also compromise the investigation. Under those circumstances, the city may be able to withhold or redact the complaint and record of the investigation. Again, California Evidence Code 1040. And then...
So let me stop you there for a second. So is there an open investigation?
It's always ongoing. I mean,
No, investigation, law enforcement.
A law enforcement of her?
With regards to the records that you are withholding.
I don't honestly know.
Are they did somebody call the police and have them open a file?
From the Arts Commission?
Yeah.
No, but the city attorney was very involved in procuring the restraining order for the commissioner.
That's not what I'm asking. The records that you have not released,
right,
that you are withholding, that you're claiming under these codes that you are reciting, are those records part of a current ongoing investigation, police investigation?
I don't know of a police investigation, but I do know that the city attorney is investigating other things.
Okay.
It's not a police investigation, but I will just say that this exact thing has gone through before the Ethics Commission.
The Ethics Commission has nothing to do with us.
Okay.
So
through the chair,
DCA.
It's not. It doesn't just have to be an ongoing investigation for that to be a valid reason for exemption from disclosure. If a lot of times in instances where an investigation has ended, someone will still try to make a request for a record, like for example in domestic abuse cases or in cases that are closed, but it would disclose the identity of witnesses that could be subject to further harassment. Those valid exemptions still apply for that as well.
But that's if those documents and records were part of encapsulated a contained case, a case that was already existing.
That's not true.
Well, that's
my office refuses to disclose public records requests that would identify complainants for municipal code violations.
Can I just?
And we have ground.
but that's part of a case. Well. Municipal code violations is part of an.
That's not a law enforcement case.
I think in this
okay,
case,
but either way, it's if the idea of the evidence code with regards to withholding records, whole records, is with regards if it's part of an investigation, and it's whether it's law enforcement or not. If it's part of an active investigation, whether there's actually a file open. The other part is whether parts of it could be redacted because it would reveal or could cause harm to a person. And just what we were hearing in the previous case.
There's constitutional rights to privacy as well.
That's right.
Also apply.
But the point is whether the entire document is then considered to not to be disclosable. We don't know that. It could be the names of people could be redacted, but not the rest of the document.
You have the right to refuse disclosure of a document in its entirety if just mere if you'd have to essentially black out or redact everything on the page. Like for example, if it's a copy of a restraining order that states the details of the incident at hand, but then just blacks out the
right, exactly. But here they withheld the entire document from.
Well, that's the basis for doing that.
No, but redacting it, and giving somebody a piece of paper that is completely blacked out is different than not giving them a piece of paper at all.
No, it's not. There's actually law out there that says if you would have to redact a page in its entirety, then you don't have to disclose it.
I'd like to see that.
Can I just interject really quickly and say that the last time I was here before everyone here, Mr. Pilpel, Member Pilpel advised her to go to the city attorney's office and petition them for the documents, and she was denied. And I included the letter from Brad Rusi, who is the deputy city attorney, who reviewed the case, who reviewed the documents, and denied her.
Okay, but that has nothing to do with the Sunshine Ordinance Task Force.
Oh, okay.
So it's, the city attorney has their privilege and prerogative to operate and the way they do in representation of their clients in that way. We're here to oversee the public disclosure of information based upon somebody requesting it and to find out what the reason for it being withheld and try to come to some determination around that. Member Eldon.
I'm not totally clear on how the rules abound. If there's a restraining order against someone, but they're looking for information about the people who they're being restrained from, I'm not clear on how the law would intersect here, right?
Well, that's what I'm trying to find out. Is the letter, the information that the Arts Commission is stating that they're withholding, if it's part of the restraining order or not, if there's some open case investigation, law enforcement or otherwise, that it's that kind of thing. Because to cite the law to protect or to prevent the disclosure of information, you then have to somewhat prove that you can do that. What about that information is not disclosable? You can't just cite it and say, okay, it's not disclosable, we should accept that whole.
No, it wouldn't matter in this case, in terms of sunshine, it doesn't necessarily matter who the complainant is if it's sunshineable information, right?
If the information is public.
Anyone else who comes in front of us could petition for the exact same information, and the restraining order wouldn't be relevant to them trying to get that information, even if it's what Antrobot wants.
Unless the information is specifically contained within the case of the restraining order, then that's something else. But that's not what I'm hearing. So
But this is not about the restraining order. This is about a statement that I made about her history of harassing staff and commissioners. So the records she requested pertain to that. So again, we don't want to reveal all the commissioners and the staff who, and there is plenty of email evidence that have written the director, written the city attorney, complaining of incidents where she has showed up at their work, where she has called their home after hours. We're not going to turn those over because we feel that the safety of staff and commissioners is paramount, and we have, we are trepidatious about her and her motives.
I just want to proffer this. I'm not trying to find a way not to find a determination, but I really want you to make the case because, there are other cases that we have like this. And if, we work on precedent based upon like our own case law. And we just got through with another case in dealing with a full redaction of 5 pages and no information being revealed. And we made an order to have as much of the document revealed as possible without revealing the personal identities of the people in that document. So it's a little bit of a higher bar if you're going to say I'm going to withhold the entire document. I mean, versus just redacting the personal information that is contained in it. So that's why it's raising a big red flag for me.
Well, when it went to the Ethics Commission, they ruled in our favor because they looked at the document and saw that there was no way to just redact the personal email address, for example, it was still very clear who had made the complaint, therefore exposing that person. And so I think that in this case, there are many documents that, even if we redacted personal contact information, it would still be very clear who was making that case. And I'm following the advice of the city attorney, so whatever you determine is fine. I just feel like I would go back to the city attorney and I would seek his or her advice on, how to proceed. But, the position of the Arts Commission is that we do not want to expose anyone to this person.
Let me ask you something. You showed this document to the Ethics Commission?
This was another case which you have the whole history on. This is another case where there was someone who complained about some aggressive behavior and to the Arts Commission. It was a member of the public, and we went to the Ethics Commission because we denied, Mr. Boo requested, any emails from X person, and we denied the request because by turning that over, it would have been clear who made the complaint, and we were afraid for this person.
Yeah, but I'm just going back to what you just said. You said that the Ethics Commission saw the document and said that it wasn't possible to redact or, prevent certain identities in that document. So did they see the original, the actual document?
In that case, they did.
They did? So it's a public document then? It's in the record?
No, it was not made public.
How is it not in public if they didn't, if they saw it in a public hearing?
They saw it outside of a public hearing.
How is it that they saw it outside of a public hearing? Commissioners. How did commissioners see it outside of a public hearing?
I was on leave so I don't know the technical, what happened technically, but it was not part of the public record, and it was evaluated by, I don't think the full commission, but maybe by one commissioner and someone from the city attorney's office.
This exact document that you're talking
No, this is different. Again, she's referring to any emails.
I'm only talking about the document you're talking about, not what she's talking about.
I'm talking about, this particular, it was probably multiple documents because it was an email chain.
Hold on.
Well, yeah, I was going the same place you were going. So,
sorry.
I believe you said that the Arts Commission has a lot of documentation on this, including inter-office emails. And am I correct that your contention is that inter-office emails can't be redacted?
No, my contention is that people who have serious concerns about this person and serious concerns about retaliation or a physical attack. I mean, this person we're talking about, let me just say, like, this person we're talking about has spent time at Rikers Island, so it is important. It is important when it comes to the safety and the feeling of staff. It is very important. When I was pregnant, this person harassed me. I think that it's really important that for those people who are scared, who want to seek help and want to...
Okay, you know what? That's fine. But I'm not going to allow you to over-talk on everybody that wants to have a word on this too, okay? I just want to say that we don't adjudicate people's intentions or their motives. Okay, that's not what this purpose of this body is for. There are other bodies for dealing with that, like the Ethics Commission or law enforcement in dealing with that. But our job is we don't have the authority to even make a determination based upon a person's. We can't even ask them what their intention is for asking for information. Okay, so while I appreciate the concern that you have, and I think we all, hear that and are sensitive to that, we just don't have we can't make our determination based on that.
I understand that, and it actually heartens me to hear that you actually have concern because, sometimes I'm concerned that I don't hear concern, with regard to this person. So that's great. I mean, again, we followed the advice of the city attorney's office, however you decide to decide this matter. And with regard to these documents, that's fine. I think that the position of the agency will still, again, to, seek, again, the advice of the city attorney. And if it means we continue to withhold all of, this body of evidence that outlines a number of incidents by this person, then we may do so. So, I mean, I respect your decision, but I'm not here to say that we're going to be able to turn them over.
Yeah. Go ahead, member testify.
I just have a couple of questions. So the emails that you're talking about, they would be in addition to the declaration of the Commissioner Sklar that was used to support the restraining order that's in the packet, right?
Yes. I mean, there's other emails from other commissioners, other staff members.
Right, but just that these are documents that are in regard to the 3-year restraining order. Is that?
No, they're not. Those are separate.
So it's separate incidents, the ones that are in the email versus
there's
the ones
many separate incidents that are not related to the restraining order.
Okay.
So I still have the question of these interoffice emails not related to the restraining order. If all personal identification was redacted, the person asking for the documents wants to determine why in your email you said what you said, and she's putting in a public records request. So why weren't these emails turned over in a redacted form?
Again, because we feel that they expose the identities of the staff people who've expressed concern about her behavior, and we feel that jeopardizes their safety.
Through the court, through the chair.
Go for it.
Evidence Code Section 1040, the official information privilege. I think this applies here. It's information obtained by, let me see here, information obtained in confidence by a public employee in the course of his or her duty and not open or officially disclosed to the public prior to the time of the claim of the privilege is made. I mean, these are people that in the line of their work are receiving threats and then telling their superiors about it in the course of their duty, and they're withholding that on that basis.
Okay. It's a good find.
For the record, she did reference that same code section earlier.
I know, but by number, but not necessarily as in words. I mean, it has to be explained. People have to make a case for their defense.
I didn't read the whole thing to you, but I did provide a lot of verbiage about that. And I also cited other occasions, including the letter from Brad Rusi, which included language around that, and then previously the letter that was submitted to the Ethics Commission. I mean, I cited all of those and provided all of those. So I felt that I was thorough in that regard, knowing that I had to provide a legal justification.
Appreciate it. Anybody else? Okay. We'll go for rebuttals, seeing that the complainant is not here. If you have anything else that you'd like to
No, thank you.
present? Okay, thank you. Members? Member testify.
I'd like to make a motion to not find a violation.
Okay.
And I would also like, after we vote on the motion, I have a couple of comments I would like to make.
Okay, great. Is there a second?
Second.
Moved by member testify, second by member Hinsey. Any public comment? Seeing no public comment. Any additional items? Seeing none, let's go for a vote. Call the roll,
On the
please.
motion, Member Kanata.
Aye.
Kanata, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, thank you. Go ahead.
And I just wanted to make the comment that apologize for not being very clear in my explanation of this complaint. But it's getting a little bit difficult with having so many complaints that center kind of around the same facts and actors to differentiate them from each other. So just putting that out there.
No problem. That's why you have the rest of us here to help.
We've all been there.
Yeah. Okay, so let me also just ask as a point of information, for the same three. Can any of them be combined, or are they completely different?
They involve similar actors, but different incidents.
Different.
And also different portions of the ordinance.
Okay. All right.
Sorry.
This should go fast, though.
I hope so. Okay. All right, call next item.
Next on the agenda, item number 7, file number 16096, complaint filed by Asheville against Keith Patterson and the Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to a meet disclosure request in a timely and or complete manner. This was heard by the Complaint Committee on February 28th with the recommendation to find violation.
Recommendation for jurisdiction.
We would like to make a recommendation for jurisdiction because the Arts Commission is an agency of the City of San Francisco.
Okay.
So I'd like to make that motion.
Second.
Moved by member Tesfaye, second by member Hinsey. Any discussion on jurisdiction? Any public comment? Seeing none, can we take this by acclamation? Seeing no objection, item is approved by acclamation. Go ahead.
So this item centers around failure to respond to an IDR in a timely manner. When we heard this item, the Arts Commission, accepted culpability for this. There was some confusion around the responsible respondent's vacation and instructions that had been given to colleagues to respond to requests in her absence, and the colleagues didn't execute those responses in a timely fashion, but the Arts Commission already accepted culpability for the violation of the timing requirement of the IDR.
Okay. Let's move on to the hearing. Is the complainant's not here? Are there any persons or witnesses to provide any additional facts or evidence on behalf of the complainant? Seeing none. Respondent, 5 minutes.
Thank you. That was very well represented. We relate and we accept culpability. I have nothing really further to add.
Okay. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none. Members?
I have just
Member
one
Kanata?
question. While you were on vacation, were the people who were assigned to take care of this and didn't do it in a timely fashion, did they take care of any other business on your behalf?
No.
Okay, because I'm just trying to see where the sunshine stuff sits in, importance. Okay, thank you.
Well, there wasn't anything that really came their way. This is the only thing I assigned to them in my absence. So everything else, and I think I was gone just one day. So, yeah.
Okay.
Anything else, members? Okay, let's go to rebuttal. The complaint's not here. Any additional rebuttal from the respondent? Respondent? Any
No.
rebuttal? No rebuttal?
Sorry.
Okay, is there a motion?
Through the chair.
Yes, Vice Chair Hunter.
We've heard this similar case like this before where, she said that you guys didn't have the vacation responder up there. I mean, do yourselves a favor, and not have to keep appearing here before us. This is old news, and you know that.
Oh, yeah, I do.
Okay. Motion?
I'll move to find a violation of 6725.
Moved by Member Moss,
Second.
second by Member Hensy. Any discussion? Any public comment? Seeing no public comment. Oh, yes, Member Fisher.
So this is going to be an administrative sort of violation, right?
I don't know what an administrative
They're
violation.
you're not going to refer it to committee?
No.
You're not.
Okay, just checking.
Yeah, no.
Before I vote, I just want to know where we're going.
Yeah.
Thank you. Thank you.
No
Member
problem.
Hensy.
Okay. All right, call roll.
This is a motion to find a violation of 67.25 for timeliness. Member Fisher.
Off the bat. Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Warnetsky, absent. Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Call next item.
Next on the agenda, item number 8, file number 16097, complaint filed by Anthropo against Kate Patterson and Arts Commission for alleged violating Administrative Code Section 67.25. This was heard by the Complaint Committee on February 28th, who referred to the task force with the recommendation to find violation.
Jurisdiction?
I'd like to make a motion to find jurisdiction. Arts Commission is an agency of the City of San Francisco.
Moved by Tesfaye.
Second.
Second by Member Kanata. Any discussion? Seeing none, public comment. Take this by acclamation. Seeing no objection. Item is approved.
So for this item, we recommended finding a violation only to responding to an IDR in a timely manner. The documents that were requested by the petitioner were specifically in reference to a case before the Court of Appeal. There was some discrepancy about whether the case is open or closed, but the documents that she was looking for were correspondence between the Arts Commission and the City Attorney's Office. Whether a case is open or closed, those documents will always be protected by attorney-client privilege. So the request came in on October 14th. A response was sent saying that a response to the specific request would be coming soon, and as of October 17th, the respondent hadn't received any documents. Now on the 18th, the response finally came saying that, these documents are privileged and you will not be receiving any documents pertaining to that case that deals with correspondence with the city attorney's office. So here we wanted to find a violation of the IDR timeliness under
6725.
yes 6725, but not a violation for failure to provide the records.
So it's timeliness.
Yes.
Okay, great. All right, so let's move to the hearing part. The complainant is not here. Any persons or witnesses on behalf of the complainant? Seeing none, respondent? Your turn.
I think that was very well put. I have nothing further to add. We accept culpability for being late in our response, and I think the way that Member Tesfaye characterized our withholding of these other documents, citing client privilege, is accurate.
Okay. Any persons providing facts or evidence on behalf of the respondent? Seeing none, members? Member Kanata.
Were you on vacation for this one also?
I perhaps.
Because I was going to ask why it was the IDR was responded to the same day, saying we'll get back to you within the appropriate time, and what happened to it?
Well, I think that what happened in this case is that the commission secretary thought another colleague was going to get back to her, but that other colleague was confused and thought that someone else was going to get back to her. So, I don't remember exactly. I think that's what it was. I outlined whatever I said in the letter is what happened.
Right. Thank you.
Do you want to make a motion?
I want to make a motion to accept the committee's recommendation, find a violation 67.25.
Okay. Is there a second?
Second.
Moved by Member Canada, second by Member Moss. Any further discussion? Any public comment? Seeing no public comment, should we go to a vote? Please call the roll.
On the motion, Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Call next item.
Next on agenda, item number 9, file number 17001, complaint filed by Anthropo against Kate Patterson and Arts Commission for allegedly violating Administrative Code Section 67.21 and 6725. This was heard by the Complaint Committee on February 28th and referred to the task force for recommendation to find violation.
Jurisdiction.
I'd like to make a motion to find jurisdiction on this matter as it pertains to a request to the Arts Commission, a department of the city of San Francisco.
Second.
Moved by Member Tesfaye, second by Member Kanata. Any discussion? Any public comment? Can we take this by acclamation? Seeing no objection, it's approved by acclamation. Member Tesfaye.
This case, we also made a limited recommendation here for violation under 67.25 for failure to respond to the IDR in a timely fashion. The immediate disclosure request, Ms. Trabeau did eventually receive the documents, but she did not get a response to the IDR in a timely fashion because it had been sent to this central email address. The Arts Commission has since discontinued the use of the central email address because of all of the technical issues that we've heard about in the past. And rather than use that email address, they are having everything go through Ms. Patterson's office in order to send those documents directly to Ms. Trabeau. So the documents were sent to Ms. Trabeau, but they were sent late.
Okay. The complaint's not here. Any persons on behalf of the complaint provide any facts or evidence? Seeing none, Ms. Patterson.
Thank you. Again, I think that was well stated. I'll just add that, we created the generic records request email at the request of this body, and it just hasn't worked. It hasn't made anything easier. There's all kinds of weird things in Outlook that make it sort of dysfunctional, so we did discontinue that. And I will say that, yes, Member Highland, we have been here a number of times about the same issue, and it's very frustrating for me personally because I feel like every time I leave here, I try to take steps to mitigate this issue. And I will say that I feel like now finally we are have like a sure-proof way of avoiding this, which is that every staff member of the Arts Commission now has a rule set up. So anything coming with IDR, immediate disclosure, is routed to me because even though we've stated multiple times our preference and around the protocol of requesting records that they come directly to me, Ms. Trabeau will often email a colleague, and sometimes that colleague's not there. And anyway, so hopefully by establishing these rules sort of throughout the agency, we will hopefully this will be in the past forever and ever and ever and ever, because I really do not want to keep coming back here about the same issue. I know that we will be back here about the same issue once again, and I think that will really be the last time. So thank you all for working with us as we try to resolve this, and hopefully we're getting close. Baby steps.
Okay, hold on. Just any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, Member Tesfaye, and then Member Hinsey.
I just have a question about the rule that you have set up. Is it an automatic rule in Microsoft Outlook that things that with those words trigger a forwarding of the email to you, or is it a rule that a staff person will forward any emails they receive with those
automatically triggered to forward to me? Mm-hmm.
Member Hinsey.
So you're the hub for all these requests, sort of along the lines of Member Kanata's questioning on the other two items. What happens if you're out of the office?
So when I'm out of the office, and which is I did this recently and it was also successful, I will set up a rule so it goes, everything coming in goes to that person.
Member Moss.
So I think that this raises a larger issue that Member Kanata and I have been addressing and Member Highland have been addressing. I think that we probably need to discuss this outside of the context of this thing. I mean, I can bring it up later. I just didn't want to bring it up later and have Ms. Patterson stick around for that if she was interested.
Sure.
But the general issue is, just to state it, is that the Department of Technology has given us the exact opposite recommendation, and they are saying everyone should have a central email box, setting up rules, which we had, Member Kanata and I had suggested, said that was totally unreliable, you couldn't do that. And so I think that one thing that would be helpful is if maybe, this is sort of, I don't think we can necessarily order this, but it'd be great to have a write-up of why this didn't work for us to present to the Department of Technology so we can maybe get them to start thinking about other solutions, because they were very, very reluctant to consider anything other than a central email box.
So I have another suggestion that I was going to offer you, and I don't know if you're familiar with this. You know what a listserv is?
Yes.
Like a Yahoo Groups?
Yes, of course.
So the city has the ability to create a listserv, and you can put any number of members or subscribers onto it. You can set it up for auto responding and all that. Very reliable, that kind of thing, because it runs on a completely different platform than just email. It sends out email, but it operates as a server. And something like that, you can then add subscribers or unsubscribe whoever you want on your staff onto it as needed, and it's pretty automatic.
I will tell you from experience that when you introduce a new platform that's related to email to city employees, that is basically, I could tell you Slack rooms that have languished. I can tell you Yammer, which is like this city Facebook channel. They have all languished. We are at capacity. It's just adding another tool. I will say that the Arts Commission will be participating in the records request pilot. The name, it's not coming to me at the moment. That will happen in the next year. The city of Oakland uses it. I think it's called
Record Track?
I'm sorry?
It's like Record Track or something like that?
Something like that. I'm sorry, I'm just totally blanking on the name, which has certain backup systems sort of plugged into it to route and also makes all responses public documents. So hopefully that will further streamline our system. I do feel like maybe I spoke too soon, that maybe I would never be here again because of the rules, but I feel like I'm sure Mr. Boo will find a way to get me back out to scene. I'm kidding.
There are a lot of concerned citizens. Whatever their intentions are, this is their forum actually. So, it is what it is. We try to do our best to try and make it fair and make it balanced. And we have some items later on in our agenda. It's going to be addressing some of that stuff. And you're more than welcome to stay for any of that, but we're going to be discussing some of those things.
Yeah, thank you, and I appreciate working with all of you. I think that initially the generic email request was a good suggestion. It just didn't. We're a small agency. I don't have a support staff, so I just didn't think it would work out for us. And so, I'm sorry that we have to keep coming back here, but hopefully we'll get to the right place, and we want that too. And we want to be responsive to everyone who emails us and needs records. So, I hope this new approach will be solid.
Okay, great. All right, any rebuttals? No rebuttal? Okay, seeing the complainant's not here. So anything else for the good of the cause, folks? Motion. You need a motion.
So we had a motion.
That was for jurisdiction. We don't have
we need a motion
violation.
for the violation.
I'd like to make a motion to find a violation of 67.25 for failure to timely or respond to an IDR in a timely fashion.
Okay. Moved by Member Tesfaye.
Second.
Second by Member Kanata. Any further discussion? Any public comment? Seeing no public comment, we ready for a vote? Please call the roll.
On that motion, Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Thank you. Call next item.
Next on the agenda, item number 10, file number 16093, review and possible amendments to the Sunshine Ordinance Task Force bylaws and complaint procedures. In regard to this matter, I have provided the most recent revised public complaint procedures that has, which includes all of the recent amendments made by this committee. There is one under B3 in which I did state that I would draft something for the task force's review and approval. It is my hopes that the task force will review this document and approve it. Therefore, I can take this document as a whole and post it on our website and distribute it with all our new complaints.
Okay. Member Moss, go ahead.
Are you suspending the rules of order for this discussion?
Yes, let's suspend the rules. Go for it.
That was my only question.
Oh, okay. All that means is you could just speak freely, but let's keep a stack so we can do that. But
well, I guess I can ask something. Victor, do you have this definition of this minimum amount of information somewhere that is referenced in this section that you just brought up, B3? Petitioner's complaints.
That would be under minimum amount of information to file a complaint. That would be under B2.
B2. Okay,
So make a reference to that. So like as per the above paragraph or as per B2. That would be good. Is there I'm looking for the edits of what has been changed. Is that in this document?
It was so messy and complicated that
all right.
I did not provide an edited version.
Okay.
But I did state where the changes were made and on what date.
Oh, where?
Usually in the title section under B. And then under C, was revised on 3/1/17.
Oh, I see. Okay, gotcha. Okay.
And usually underlining is our additions.
Right. So did you use that nomenclature to do the underline and the italicize and all that stuff?
Underlining are the additions and strike-throughs are deletions.
Okay, you did.
Italicizing
is amendments.
Has no significance.
Oh, okay, great.
But this has been changed for so long. It's been amended constantly for over a year that it wasn't possible to show everything.
On page 371, bottom of 371 and the top of 372, I would just, instead of ending, it looks like you said it here, this is for reconsideration. If a petition for reconsideration is granted, a new hearing on the complaint shall be scheduled at the next SOTF meeting. Is that an actual strike-through? Looks like it was by hand. It was done by hand.
It is a strike-through, but I believe that that was necessary because it could go to the complaint committee or the full task force. So I didn't want to I didn't want to state complaint committee or full task force. I was trying to leave it open.
I would say, it feels like it's not a finished sentence. I would just, new hearing on the complaint shall be scheduled. Okay.
I can state at the next.
You could say before the SOTF or one of its committees.
Before. SOTF or one of its committees.
Or before one of its committees, or one of its committees. I would just,
And I left that language like that to leave it at the discretion of the chair to determine where would be the best fit.
where does it doesn't say that.
Well, it is assumed on the last line that issues not designated by the procedures shall be at discretion of the
Okay.
of the chair.
Okay. Fair enough. Okay. I don't see anything. Everything else looks okay. How about anybody else? Have anything coming up for anybody? Shall we? So this is obviously a living, growing document. We can approve it for where it's at now. If we see something in the future, we can make adjustments on the fly. Okay.
Point of order, kind of, with these.
Yeah, sure.
So we make changes to our internal procedures. They don't have to be approved anywhere.
No, the ordinance requires us to create our own bylaws and thus the procedures for what we.
But they don't have to. I mean, at my agency, we can update our rules of practice and procedure, but then it also has to be reviewed by the Office of Administrative Law. Now, I'm not saying the Office of Administrative Law would be reviewing ours, but I don't know if there's like a similar body for the city.
There.
Maybe DCA Cola knows.
He is our.
Okay.
He is our oversight.
But see, at the state level, the Office of Administrative Law can review and say, no, this is not in line with the larger ordinance.
Okay.
Like, and so I was just wondering if for us, as well as any other body within the city, if we change our rules of practice and procedure in some way, is there any other organization that needs to review that? Or we just go ahead until someone complains?
I think it would really depend on the change.
Okay. So if it was a certain type of change, it would go before whom? There's no similar.
I think we've got the right here to make changes that we see fit. If there's an issue of due process, or if there's an issue of are we altering something that was approved by the voters.
Right.
Those are the sort of questions that I would take back to my office and would probably require a little bit more analysis. But
okay. But
if
there's
there's
no
issues,
that
if there's
does
issues here that we don't think anything comes of that, or anything rises to that level, I think we're within our right to change them right here.
Okay.
Yeah, and I think DCA Polo will red flag anything that he comes across. Let us know.
I read through all these, everything that we have here so far.
Okay, good, thanks. All right, shall we approve these? Okay, let's get a motion on the floor. Nobody wants to approve these.
Sorry, I have another question about this. Sorry, to jump back to this.
Don't be sorry. Just go for it.
So to jump back to this minimum amount of information, I just want to make sure that we know what's going to happen because I think that Mr. Hartz had raised some questions about Victor's ability to decide whether a complaint is going to make it past him as a gatekeeper or not, and I just want to be sure that everything on here is okay. So.
I believe the new item 3 would take that into account, and that if I can't get a correction, I would schedule it for the full task force to determine whether or not to accept the complaint or not.
Okay. Sorry, can you explain that to me again? I'm not sure.
I believe it's when I do not receive the minimum amount of information, I try to contact the complainant to try to get that information. And if I do not get that information, I would schedule it before the full task force for consideration of not accepting the complaint. So eventually it will get to the full task force for you to determine whether or not to accept an incomplete complaint.
Okay, so I'll just reiterate. So if somebody comes to you and they don't have this minimum amount, you try to get it from them, and if you aren't able to reach them or they aren't able to provide it, it still comes to us, and then we have the option to decide whether to not accept the complaint or accept it as is. That sounds like exactly what you just said. I just want to make sure.
Yes.
I was making sure I understood.
Yes,
okay.
That's the purpose of the addition of item 3.
Okay, and then things like I think I've got it under control. Have we had that many cases where somebody, what have we done in the past when somebody did not have a reliable method of contacting, or you contacting them?
That one is kind of a no-starter. If I can't contact them, I can't ask them, and I can't even, no way for me to inform them of a complaint hearing. So that is one of the items where I would not accept the complaint because I don't know who's complaining.
Right. But that would still come to us for us to make a decision on.
I believe so. If upon approval of this, yes.
Okay.
Motion?
Motion to approve?
Second.
Moved by Vice Chair Hyland, second by Member Hinsey. Any further discussion? Any public comment? There's no public. Should we move to a vote? Call roll.
On the motion, Wolf absent, Copra absent, Member Tesfa. Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky absent. Member Eldon.
Aye.
Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, great. Next item. So I think we can have a little discussion about, I think the next two. So rule of reason.
So I was going to suggest that today would be maybe a good day to talk about the vexatious stuff, since we've just had like quite a bit of a discussion. I don't know if other people aren't.
You want to lead it?
Not exactly, no. But it is a difficult. I don't know that we'll solve it today, but it's probably worth talking about a little bit since we have it fresh in our mind.
Sure. We don't have any existing rules on this at all. I'm not particularly in favor of the word vexatious because it has certain connotation, especially in court and for courts and whatnot. But I think the context, I think, is important. And really, it's the question because it can come down to just excessive number of requests or petitions, or it could be something leading more down the line of the spectrum to malicious, which implies intent. So,
well, my first question is whether we even can do anything about that under the Sunshine Ordinance. Like, do we even have the authority to label someone and say that they can't appeal to us anymore? And if we can't do that, then we can just sort of never deal with a vexatious issue if it's outside of our purview.
Well, I think we had some discussion about something similar to this regarding the duplicate findings or the multiple findings that we would try to find a way to space them out. So if they were to make like 3 submissions within a certain period of time, that the fourth or more petitions would be scheduled later on, so that there would be enough room. We have 1 or 2 regular folks that complain that we bring too many of their items up at the same time, and it flusters them. And I usually respond to them outside, just privately, and say, well, then don't make so many requests, and then you'll be able to manage them all. And they don't necessarily say, you're trying to block me from being able to file a complaint. I'm like, no, but it's just manage what you can manage, and that's it. It's not like we're just a machine here and just rolling things along. You got to do your part. So I think along those lines, it's really the incumbency upon the petitioner. We'll do the sausage making, but they have to manage it through. They have to turn the crank, pretty much. So I don't know. I don't know what you want to do prior to that. Victor, did we already pass a rule regarding the number of complaints?
No, there is no rule regarding that, but it's an informal procedure in that.
Okay.
I'm limiting In order to be fair to all parties,
Right.
I'm limiting the total amount from one person per meeting.
Okay, but I think what we might be interested in doing is sending some sort of communication publicly that we're going to be not limiting, but parsing, the number of petitions that a person submits in a certain period of time. I think that's worth a discussion. And if we can come up with a rule, then we can come up with it. Go ahead.
Can we talk about, in the same vein, combining
Well, I think
cases?
combining cases is really, we've left that to the committees. So that way there can be some discussion about, whether the details or the context of the cases.
Okay, so as an example, the ones today, the last three where they were the same complaint and the same respondent, the same 6725,
Right.
and the same admission of guilt.
Right,
on all three.
So that's why I had asked in the beginning, can we combine these?
Yeah.
And we were recommended not to, so.
Okay.
And I can explain why I didn't. And I don't know
Right.
if I don't know if I made that recommendation via email to you. I think it was via email. I didn't do it here.
Right.
And that was only because they had to do with completely different incidents, different documents that were being requested. I think that if I would have been more likely to want to combine those had they included all the same information that you just mentioned, same department, same petitioner, same section of the ordinance, and the documents that were being requested were the same documents as well, or the same documents on the same, or different documents even on the same subject matter. But one had to do with documents for a court case, another one had to do with the just all different kinds of topics. So that's the only reason I didn't think that was appropriate. But we had combined some complaint cases from Ms. Tribeau that had the same topics in the past, or also the same records that were requested. So I don't know. Same nucleus of operative facts is usually is how we're looking at it. Okay.
So what do you think about creating a rule for that actually provides a communication to petitioners that if they're going to submit X number within X period of time, that X additional number will be, scheduled at a later date or within a certain X period of time, so they have some expectation when they'll be heard.
I mean, do we have to get into the time factor, or can we just have a number of, we will hear X number of cases from the same petitioner in any given meeting?
You could do that too, sure. Everything is on the table for discussion, so let's
To me,
brainstorm
that
it
seems
out.
to simplify it, instead of saying, well, if you put in 5 in the period of 3 months, you're not going to get the 5 heard at the same meeting, things like
Right.
that.
So if we can average, let's say 5 cases a meeting, let's say that's kind of the average of what we handle. Sometimes it's less if they're really meaty, or they're more if they're pretty simple. Let's say if it's an average of 5, how many from the same petitioner would you be willing to hear in one meeting?
2.
Okay. Anybody else
That
have any concerns or interest?
You're suggesting two by the same complaint with the same respondent per meeting, or 2 from the same complaint?
I don't think it has to be the same respondent.
Just any 2 cases from the same petitioner.
And does the petitioner in this case refer to an individual, or does it mean that the Chronicle, for example, could only have 2 cases, like the entire organization of the San Francisco Chronicle can only?
No, it's whoever makes the submission for a petition for hearing. I'm calling it petition for hearing because that's how the ordinance refers to it. But anybody that makes a complaint.
Okay.
Organization, any entity, person, whatever, whoever makes a submission.
And we could have in there, God forbid we ever catch up and don't have that many cases, we can say, if time permits, there could be more, but.
Right. Yeah, Victor and I work pretty closely on scheduling cases and which particular cases, and because sometimes I'll say, that one's going to be a lot of discussion, or this one is, there's not enough information, we're just going to send it back to committee, so it's a simple, quick kind of thing, or that kind of stuff. We review those things pretty quickly. Just go ahead, speak up.
And how will we?
Go ahead. I just want to talk about the 45-day limitation.
Exactly.
Right.
That was my exact thing. So.
Right. So the 45-day rule specifically is regard for public disclosure requests, and all that matters is that the task force determines whether the information is public or not. That's the only determination that satisfies the 45-day rule. We have authorized any of the complaint committees. Any committee hears a complaint, that if they hear it and make that determination within 45 days that satisfies it for the entire task force process.
Until we could continue it. We can say we found that it's a public document. Now we'll just continue it.
Right. I mean, actually, we can do.
In writing?
I think in a couple of years they actually had done this when I first started, was all the complaints that were in the hopper that were 6721 and 6725, they were just given to the complaint committee, and they would just go down the line and make the determination of whether they were public or not, and then it would be left up to the administrator to schedule it. So at least everything that was submitted could be, in one fell swoop for that period of time or that month.
By email or by in a meeting?
No, in a meeting.
Okay.
In a meeting, absolutely.
I think that'd be useful if we have to do that, especially so we don't get tripped up in front of ethics like we did that one time.
Right.
But I think the public perception is that they're going to get their cases heard in their entirety within the 45-day. That's a misperception by the public.
It is.
But you'll hear that a lot, that, I wasn't heard.
We'll make it painfully known.
Yeah.
We'll repeat it many times.
I'm just wondering, wordsmithing the limit of cases issue that we were talking about earlier, maybe if we just have a note somewhere saying that, more than 3 cases, or we might be able to handle 3 of your cases in a given time period. Anything more than that, the chair is to the call of the chair to put you to the back of the line so that other people can have their day in court, so to speak, something along those lines.
Well, the scheduling of complaints is currently at the pleasure of the chair in creation of the agenda. So
right, but I'm really getting at the multiple offenders, so to speak.
Oh yeah,
the ones that
the multiple submitters,
the serial submitters. There we go.
Okay.
So submittal of more than 3 cases in a calendar month may mean that your additional cases may be added to the back of the line to allow other members of the public to be heard, something like that.
Well, I think that's what we were kind of going on, trying to figure out what
the language.
Yeah, I think what Member Canada was saying is like we could hear 2 cases from the same petitioner in any one meeting. That's the maximum.
The balancing act of that, as Victor will tell you, sometimes it's good to hear X amount. Like, I think if you work out what that number is, maybe 3 is good, because then it's worth getting the police department here for those 3 cases. And,
Yeah, sure.
But I think 3 is probably a good number. We can always adjust that downwards.
Sure. I mean, the thing is not to make a too hard and fast rule, so it provides us with some flexibility.
But that kind of language also takes out the word vexatious if we just
Yeah.
make it a volume thing.
That's right. That's right.
If we reduce it down to, say, like 2 cases, like Member Canada had recommended, is that going to have the practical impact of a requester who would normally file a complaint every single time something bothers them, and instead compile those, spend a little bit more time to compile those into 2 complaints, so that actually the same number of grievances, but in a smaller number of actual things? And is that a good thing?
That's a good thing, because we'll have the set amount of time for hearing that case. Yet we have more facts. You don't have to go through the the mechanics of.
Yeah, we're just trying to set up a traffic light system here, just a little behavior control.
And some of the more experienced petitioners will sometimes take one incident and slice and dice it into 3 cases, which, and then they object when we try and combine it. So I think some sort of traffic light guidance will cover us going forward.
Would this apply to both committee meetings and our full meeting, I'm assuming?
Well, yeah, because the scheduling will be exactly the same for the committees, I would think. But, you know, the thing about the committee side, it's really more about creating the record, the file, and making sure it's really more, you know, very process-oriented than adjudicating it. But it's up to you. If you want to extend it to the committees, we can do that too. You know, to have committees not hear, you know, more than 2 submissions from the same petitioner. You know, just have that as a general rule all the way across, whatever your pleasure is.
Yeah, because if it's 3, they can combine it into 2 if they write it well. I'm fine with 2.
We can try it, see how it goes.
And just throwing out a sort of random idea, is there any value in trying to set it up that we can have an Arts Commission day every 3 months or so, or whenever? But I mean, no, I'm like a library day every 3 months and an Arts Commission day every 3 months.
Do.
Here's the thing.
So that everybody doesn't have to come.
Yeah.
Done it in the past.
Yeah.
The thing is that, like, so we heard three cases tonight about them around timeliness, okay? That's really on them to get it corrected, you know? And then, you know, how many times you want to get slapped on the wrist, you know, before you start, you know, kind of getting with the ball, you know, with the game here, no matter who is doing it, you know, so.
Or even if there are no documents to turn over, you know.
Right, just, it's that kind of thing. And look, if it's an IDR, I think a good training for folks. If it's an IDR, if at the moment there's nothing responsive, that's fine, because in IDR it requires documents to be provided on a rolling basis anyway. So you don't find something today, but you find something tomorrow, and then you send it out. So it gives that kind of there's that. I don't think anybody realizes the flexibility, you know, with regards to that. So they just need to respond within the first business day, and then provide any documents or any response within the next 10 days. So, you know, if you don't have anything in 10 days, then something shows up in 20 days, then you send it along. They just got to keep track, and most of these folks do. I've gotten pretty good results myself. So.
Well, I roll back that brainstorm to get back to the 2.
Okay.
The 2 number.
Go for it.
I don't have a motion.
Okay. Well,
I'm not exactly sure how to phrase something like that.
When we make the motion, do we have to phrase the language?
I would say we should at least get as close as possible. You can keep it conceptual. Well, you know, Victor and I can wordsmith it, but I think the concept should be very, very clear. That, you know, right now, so what I hear people saying is we don't want to hear more than 2 cases in any committee any committee hearing complaints or the task force in any one meeting.
That doesn't stop them filing 5, though.
That's right. But they will be parsed out over time. Then if they do 4. In May, 2 will be heard, and in June, the other 2 will be heard.
Okay. I guess that's implicit, but should we be explicit about that, saying that anything over...
Make a suggestion.
We're playing with that 45-day rule, which I don't want to, because that's part of our charter. But I'd say that, you know, your first 2 will be heard within 45, or will be... agendized within.
It's hard to do 45 because we're on a 30-day cycle. So
yeah, I don't want to get into that, but I guess that can be something that the clerk communicates by email or on the phone as they're piling up, and just say, just so you know, we only hear 2 within a working period. The rest will have to go to the back of the line. You might want to rethink, repackage the 2 you have, or.
I think just telling people that we're only going to be hearing 2 items. If Ms. or Mr. Petitioner, we are only going to hear two of your 4 items in any one meeting, and the scheduling is at the pleasure of the chair. That's,
The 45-day thing is just for 6721, right?
6 and 25.
And 25, okay.
Yeah.
How about in the event that somebody files so many complaints at one time that are 6721 or 6725 related, they no longer have their right to request a hearing before the full task force, and some of them automatically get parceled out to subcommittee.
So that's the way the previous iteration of the task force operated. And over those years I've been, and I have a problem with having only 3 members adjudicating an entire case. I think that we are all here to hear the full merits of a case, and we should, people should have the benefit of that. Both parties, all parties, should have the benefit of all 11 of us or 10 of us at this point. I just don't feel comfortable that we become a rubber stamp board where it gets adjudicated by 3 people, it gets presented as a recommendation, and then the merits are really glossed over because people get comfortable with expediency. I don't think that's due process or due diligence. So that's just my feeling. I mean, you guys want to overrule me on that, you can. But I think the way we've been going about things right now, I think people are getting a very fair shake. And we've been actually able to get through. Finally, I think things are kind of moving along pretty well. So, but I leave that up to the rest of you. That's my rule. It's the way I feel things should operate. Again, you want to overrule me? It's fine. We can have a discussion about that. Okay, so 2?
Yeah, I think 2 is fair.
Okay. 2, everybody okay with 2? We can change it later if people complain too much or if there needs to be some alteration or anything like that. Okay? So let's get a motion on the floor for that.
I move that we limit the number of cases by the same petitioner to 2 at any given committee or full board meeting.
I'll second that.
Moved by Member Kanata, second by Member Moss. Any public comment? No public comment. Any further discussion or comments on the motion?
I just want to state, in addition to that, is the chair able, time permitting, to exceed that 2 limit? Like, if there is space, can that limit of 2 be exceeded?
At the discretion of the chair.
Do you want to make it at the discretion of the chair?
Yeah, absolutely.
Okay.
All right, so I'll second the amended motion.
Okay. Accept that friendly amendment. Okay. All right. Call roll on that.
On that motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey. Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon. Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Great.
And associated with that, if they do exceed the 2, in regards to the 45-day rule, should I be scheduling those just for determination, or?
So I would say I want to reaffirm that we authorize the committees that hear complaints to that their determination of whether information is public or not is an official decision of the Sunshine Task Force. I want to reaffirm that because I don't necessarily recall if we actually took action on that. So I'm not, just to be safe, I want to reaffirm it.
Okay.
So I'll make a motion to authorize any committee that hears complaints to make a determination of information to be public or not for the purposes of 67.21 and 67.25 as being official determination of the Sunshine Ordinance Task Force.
Seconded.
Any concerns, discussion on that? Seeing none, call a roll on that. Thank you.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon. Aye. Eldon, aye. Josh Wolf, absent. Cooper, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, great. So now with regards to scheduling those, the 45, just for the 67, 21, and 25s, I don't think we need to have a rule for that. I think it's just a matter of scheduling.
Yes.
But the idea is just whatever comes in that's a 67, 25, or 21, just put it on whichever upcoming committee it is, and committee chairs, your only job is to just determine whether the information is public or not, and then make a ruling, and then that will satisfy the 45-day rule.
In notifying the complainants,
Yes.
should I tell them that we're only going to make a determination regarding jurisdiction and we're not going to hear the complaint yet?
Right. This is
Okay.
only, it's not even necessarily jurisdiction, it's whether the information is public or not.
But we're not
Because-
going to conduct a hearing on the actual
Right.
complaint.
This is only to determine if the information requested is public.
Yes.
So that,
Complaint committees, are they going to be doing the sort of what we're calling fact-finding
No.
mission that we undertake?
Well, they won't be doing the 45-day rule stuff. It's only the committees that hear complaints. Is that your question?
But say member Kanata's committee here's a public records complaint. Do they do the same fact-finding procedures that we do at the complaint committee?
Oh, yes. Yeah, that will be scheduled differently.
so you're, that was going to be my question.
Yes.
So it's going to come to committee twice then?
It'll come to committee twice, but it just to satisfy the 45-day rule, because once we satisfy the 45-day rule, any of those can be scheduled at any time.
Right.
If it's at our pleasure, really at our pleasure at that point.
But if, okay, say the committee has 6 cases, and you can get through them all that night, not only determining if the records are public.
But see, currently you receive your agenda already cooked. So you'll see like a section that will say 45-day rule determinations, and then another section that
Okay.
will be actual complaints.
All right.
That, hearings kind of thing. Yeah.
And can we take the 45-day rule determinations like a consent agenda? Like if there is an item that the committee members ahead of time have determined would not be a public record, then we can move those off of the consent agenda
Well,
for a
let's see.
a no vote?
Usually, you mean as a consent agenda?
Consent
I know,
agendas,
consent
we can-
calendar,
so
all
you
at
can-
once.
Yeah, take them all at once. Unless there's a no vote, then it would be moved off of the consent agenda.
So
the committee chairs would have to review each and every one to be assured
Ahead of time.
ahead of time.
Which I think we should be doing.
Yeah,
I think we should be reviewing the entire packet ahead of
I
time.
just don't, the concern I only have with that is if that for some reason something slips through and it ends up, and something becomes more regular, happens often, that it comes to the task force and then we find, this is really not.
I mean, I think the
public
concern is
information.
I think it's more of a concern if it's the reverse. If we are not finding something to be a public record. If we're finding something to be a public record, there can still be reasons why it's not released. All of the exceptions.
Right. Yeah, I mean, that's why I say it's different than jurisdiction. So it could be not public information, but still within the jurisdiction for the task force to hear. So that I want to separate those two. But I think doing it by consent calendar is kind of, I like to use that term. I think you have to really make sure that all those items are in the direction. Either they are all public or they are all not public.
Well, I mean, if something is not public, then you would move it off of the consent agenda to be individually looked at.
But there's assumption by members that if you create a consent agenda, that somebody has reviewed them all, that they are correct.
I mean,
but everybody should also be reading them too to make sure.
Right. I thought. Yeah. I feel like.
Yeah, but creating the consent would have to come out when the draft agenda comes out.
Yes,
right?
it would come out with the draft agenda, but an item can be moved.
Right.
The item could be moved off of the consent agenda.
Yeah. So I
as
have
long
a question. If we go that route, even if we don't go that route, and we have the grouping of 45-day items, do we have a complaint, a respondent? Do we have public comment?
Yeah,
you have to have public comment.
That's my concern.
Yes, you have to have public comment.
If it is a consent calendar, is the public comment on the calendar?
Yes.
Not on each individual item.
Right.
Okay.
And I mean, any voting member can pull an item. I don't know that a member of public can pull an item, but a member of public can request an item of any voting member to pull, or ask the administrator to request the item to be pulled. It can be that kind of can be done.
Yeah, they can request it, and any member of the committee can. Like the public can request it, but it won't necessarily happen. But if any single person on the committee wants it moved off of the consent agenda, it has to be moved off the consent agenda.
When it's moved off the consent agenda, does it become a hearing?
No.
In that case, no, it gets rescheduled.
No. You just hear it individually. And
for that limited reason.
For that one particular, it's just like having any motion on the floor.
And when you say hear it, it's just a discussion amongst the committee with public comment.
Public comment.
Okay.
That's right. And so that way, the person who's concerned about it has the ability to address it, that one specifically.
Because that usually signals, if it's pulled off of the consent agenda, it signals that it's going to get a no vote.
Right. So. Or there's some question.
Some question, or
right.
Get a no vote so someone can speak on.
Yeah. Sometimes we don't know if it's public information or not. There's the Jason Grant Garza case with HIPAA information and whether documents that are held by the Department of Public Health are actually public documents, and how should they be released? Well, the function under HIPAA is that they could be released to the person if it's that person that's asking for it, not to a third person or second or third person. So it then became a sunshine-related case. So it has sometimes it's a little gray areas that and gets a little tricky, as you said. Okay, so we'll just leave the scheduling kind of open, and so that way we can have some flexibility on scheduling those. So just to remind you, when you're running those 45-day rule things, they should be like very quick, absolutely quick. There should be, you should be running through them like pretty lightning fast. If you have to do them one at a time, or you do it by consent agenda, you'll get used to it once you get rolling. Okay, one more. Pick one.
Well, rules of reason, right? I mean,
This one.
Yeah, it sort of follows.
Okay, so the rule of reason. So the rule of reason is viable, feasible, active, and all that. I think the issue is much like withholding records and having to somewhat prove your, the provision that allows you to do so. On the rules of reason, I think we have to find a way for them. There has to be some bar, I guess. I don't know whether there's a bar or whether, I don't know. I'll leave it open for you guys to discuss it. Go ahead, DC Cole.
Through the chair. I mean, there's a lot of case law out there on the rule of reason. There's no exact science as to, it's not like there's strict elements saying, well, you need to fulfill this requirement and that requirement and that requirement before you get the rule of reason. But they have a test. I don't know it off the top of my head, but I've included it I've included it in some of my memos before where a respondent invoked the rule of reason. Maybe we could just incorporate that into the bylaws and say, if you are asserting a rule of reason claim, please include an explanation as to how your case meets this standard.
Great. Yeah, I think that's good. So I was going to ask, is there some baseline standard? So if there is, I think that's a good way to go about it. What do you think? How about on this side of the dais? The right side. Not the right political side, but just to my right. But you're the correct side of the dais. What do you think about that?
I think just forcing people to explain it sounds a good next step.
Okay.
I mean, it's sort of like the definition of pornography.
Well, but it's not. I mean, they really have to it has to rise to some at least baseline or standard that meets what, a good reason.
It's just like, it sounds so inherently subjective, and it's
I know, but then if we don't do anything about it, then we'll have every single respondent come in here claiming the rule of reason that it's becoming too. I mean, if I compare what Kate Patterson is going through to what Lee Hepner is going through, it's apples and oranges. I mean, it just the 20,000, quote unquote, 20,000 emails. I mean, there's so many tools available to parse through 20,000 emails. It's a little more difficult to be dealing with another human being directly, so, I think there needs to be, somewhat of a baseline that we can count on, that we can say confidently that we understand that. Go ahead.
the closest thing we can get is making other people do their work, right?
Yeah.
Why are you being reasonable?
Yeah.
Don't ask me to define it.
That's right.
You tell me why.
That's right. That's our entire purpose in life here. Yes.
I think in the past, the task force has asked that the respondent provide a small sample size of how long it takes them to provide a portion of the records so that the task force can see how long it would actually take to provide the entirety of the record. And that being the proof that it is the rule of reason would apply.
Well, I think DC Acola has a standard that he has cited also in some of his advice memorandums, and we can include that. Maybe create some synergy between both of those. Okay, great. Okay, so let's wait for that, and then we'll have something we can look at, touch and feel, and we'll take it from there. All right, that's enough for tonight. I think the rest, there's nothing is pressing as far as the rest on that list. Victor, is there anything on
Nothing
that list?
pressing.
No? Okay.
Wait, the public records on personal devices?
Are we
Yeah.
adjourning for?
Is
that what's happening?
I feel like that issue is.
I have that on my chair's report, which is next, so we'll get to that. But as far as the rest of the items on this bullet list, there's nothing pressing?
No.
That we need to, okay, great. Okay, so call the next item.
Next on the agenda is item number 11, Sunshine Ordinance Task Force Chair's Report.
Okay.
There are 2 items listed.
Okay, so this is where we can discuss Smith versus San Jose. And did you see the document that came out of the city attorney's office from DCA Zarefsky?
All 18 pages.
Yeah. So, I think, that's going to be important for us to review. I think, if we have any suggestions or concerns or anything like that, I think we can have a good discussion with DCA Zarefsky on that. And, sometimes they see things in a certain way, we see things in a different way, and maybe we can come to some synergy on that. I think that would be good, a good thing. Yeah, absolutely. Go for it.
All right, Nick. So this is a microphone thing, right? So I did read all 18 pages, and it almost resonates with something we talked about like 2 hours ago about that, like, what was it called? Like the camera.
In camera.
In camera, thank you. It means something totally different to me as a photographer. But so my question was, I read through that thing, and obviously, the first thing I thought was, crap, people are going to look at my emails. But as I read through the whole thing, I actually agree with it because people have been using it as a shield. So my question is, something happens, and all of my personal emails and my texts and whatever are subject to disclosure. Is there a non-biased, impartial third party who reads through those and says, all right, if Lou texted her girlfriend, I'm at Sunshine and I'm so bored, that doesn't count. But if she texted, I'm at Sunshine and this guy, Fred Flintstone, is really bad and I don't like him and I'm going to vote against him no matter what, that can be disclosed. Is there going to be is someone actually going to do that?
In theory, yeah. I don't know how it'll be implemented, but it'd probably be some sort of it'd be pure speculation at this point. I don't know how they're going to...
But is the spirit there? I don't want... If I write, oh, Amy, I'm so bored at Sunshine today, that has nothing to do with... And I wasn't bored today, by the way. It was a very good day. That has nothing to do with, the way I read it, it was city business. And I figure that people are probably doing city business on personal devices, so this is good for that. But is it going to be purely city business? That's my issue here is there going to be a line and a delineation? If I write something on my text machine and it's city business, then yeah, that should be disclosed. But if it's personal, I don't want that disclosed.
So let me, if in number 3, Mr. Zarefsky, DCH Zarefsky says, as a general rule, city departments will satisfy their duty to search for records on employees or officials' personal device in response to a public records request by entrusting the employee or official to conduct the search and retrieve responsive records.
And that's what the court case said.
Right.
And they can come up with, the city can come up with its own policy as well on figuring that out, but the court did not require that it be done by a third party. Employees at this point can do it on their own as well. That can become a policy.
Well, wouldn't that defeat the purpose if you said to me, okay, give us all of your texts that had something to do with city business? Okay, here they come, yeah.
The city can come up with a specific policy on figuring that out. Like, for example, you're not allowed to use your personal email at all. But, on remand, the case allowed for employees to search their own email.
It sounds like the honor system either way. You can't use your personal email to conduct business.
That could be the way the city sets up the policy, but they haven't figured all that out yet.
And they haven't figured out how to police it and get the appropriate information. But
They don't have any system yet, but
Right.
let's say a scenario where they say, "Oh, I don't have any responsive records on
Right.
my personal email," and then a third party who you sent an email to that was totally relevant says, "Well, here you go." Well, then
Right.
maybe they've got a process for
Right.
contracting with a third party who has some sort of confidentiality agreement and to sift through your emails. And
Right, but we get, I don't have responsive documents from departments also, and we accept that,
yeah,
right?
Go ahead.
So-
Anyone else?
Eldon was next.
I mean, this isn't really about this specific case. This is like my biggest concern about this is that it's like you don't. It's like the whole world is moving towards encrypted messaging and disappearing messaging apps, and this is like a national issue right now in DC. And it's like it's disturbing because it's like it's now this sort of cosmic battle between either all privacy or all transparency, and I don't really know how to deal with that. I mean, I know some of you in the room work on this more closely every day than I do, but I feel like there's like, I mean, if I wanted to like ensure transparency, I would promote the idea, and I do, so I'm like leaning this direction, but it doesn't really feel good, of like banning the use of Signal and banning the use of like maybe even Snapchat or anything else where it's like very hard to access because like, and if like you can't do government work you can't do taxpayer work on those kind of apps because they deny the ability for the taxpayers to see what you're doing. But I don't know if that's even enforceable.
Right.
Go ahead.
So I think the issue he's addressing is a retention issue, and that's talked about in the, that is up for the city to decide what the retention issues are for personal devices and whatnot. I think that for us, one of the issues is that when somebody comes in here and files a complaint and says, "I asked for these records, I don't think I got these records," that we need to be able to ask the respondent, what did you do to ensure that people checked their personal devices? And that's about all we can do. And if they say, "Well, we didn't ask anybody," well, then that's not a good enough answer. We need to send them back, and they need to send an all-staff email or something of the like saying, "If you worked on this, please check your devices." I think that we might run into issues with like third-party searches of things with the California Electronic Communications Privacy Act in terms of having a government entity search a personal device without a warrant. But in the event of something where somebody has hidden something on their device and everybody knows they hid it on their device, then I think that just goes to ethics, and then ethics takes it to court, and that's how it has to play out.
But the decision does not require a third party to search
No.
the emails.
No.
Right.
It does not.
No.
In response to Member Eldon's concern, I think what is going to evolve is the prohibition of using any of those apps. So if a device was subpoenaed and was found that the app was found on that, then there'll be the threat of some criminal consequence.
Yeah, but that's not going to work. That's not going to work for us sitting here. None of us are provided a government device. None of us are provided a government.
But it's personal device, not just government devices.
Right.
So
my personal device, like you will never find me not having Signal on my phone.
Right.
Like that is
That's
just
right.
a line in the sand.
So here's the thing. Remember at the beginning.
And that same should go for you. And same should go for all of us.
Right.
Like,
No, I agree. I agree.
don't even know what
and
Signal is.
I want you to keep that position because of where you come from. But
Sorry, Signal is a messaging app that everyone should install that allows you to communicate it allows you to communicate with others through an encrypted text messaging system. So your messages, only you and the other person have access to that. And it also does phone and video chatting, all that sort of stuff, and it's an open source thing. So no GIFs so far. But in any event, it allows for encrypted communication. And the concern with government is there are people who work in the government now who are afraid of, say, the Trump administration, and so they communicate over Signal so that they're able to do
Or say
that.
the Trump administration.
Or they are the Trump administration. But also after the Clinton hacks, Clinton campaign staffers started using Signal because the idea is that you want to ensure that if you're hacked, all of your communications aren't leaked onto the internet. So
Right.
that's the kind of short version of it.
So that's why when we first came on, last June, I said everybody needs to create their own, because in general, that is the Smith versus San Jose's case actually applies anyway. Okay, it's just now it's been a court has actually affirmed it. So my concern is even though you've all created separate email accounts, those are still could be accessed in general. The thing that I'm kind of trying to inquire about is whether we all can actually get city email accounts, okay? Because then you don't have to worry about it. They would have access to it anyway, and then there's no need for any of us to be bothered with having them. It just removes one step of uncomfortability.
Also, the retention issue would be.
And the retention issue would be there. They would have backups. They would be archived, and all that stuff would be searchable.
Yeah. But that's still not going to fully fix it. I mean, if you're on Twitter, somebody might DM you, and you have no control over what they're going to send you on a private channel.
But you can sunshine it.
Right.
Right,
So,
but I'm just saying for the purposes of us volunteers, because this can be very onerous for us because, we're not paid employees. Most of our lives are not doing this. It's, a small percentage of our hours of our lives. So I think, whatever makes things a little more facilitated for us and safe for us. And then you know that there's a delineation line when you log in. So I've inquired with the clerk about that, and we'll see what the outcome is. I don't see there being a problem. I think every commission that has volunteer, members to it they should fall in the same rubric, and that way they can feel very confident. Because if they do get called upon and their personal devices are asked for, nothing should be found. There shouldn't be anything. You should be very confident about that. And so as things evolve, when they do find a way, either backdoor your phone or something, then you'll feel safe that they're not going to find anything. So that's kind of what I've been working on over the past few weeks to see if we can make that happen. Does anybody have a concern about that? About receiving a city email account for the purposes only of Sunshine Business?
Yep.
Yeah.
So no, but I mean, no, I actually think that would be very helpful, but that doesn't necessarily change the fact that I take notes sometimes on Google Docs, which is going to be a private account through whatever Gmail I set up for this or other services I might use.
Well, I'm not, maybe Victor can answer the question, but I wonder if an account was created, if it comes with Office 365 online, the online version. So you're logging into a cloud-based system, nothing is saved on your device, kind of, not saved, but it's not, everything is more or less sitting on the server.
I mean, I'm happy. I mean, I find it okay for me to silo things and have a folder where I have all my minutes and my notes and things like that. The issue is that if somebody files a request with Victor, how am I going to hear about it because I might have responsive documents? But that is, how I've been functioning all along because I think the Smith decision is the right decision. That's how I've been functioning, But there needs to be a process for departments in general where it's not the only search, right now, a lot of times the only search, a department, whether it's in the federal government or here, is the general IT search for things without actually even talking to the person that would have the records and asking, is it somewhere else? Because all we did was search your email. And I think that maybe needs to be what needs to be institutionalized.
Okay.
Like a good communication system, like in all staff, do you have records, kind of thing.
Right. With regards to that, for sure. No, I hear you on that. Okay. Well, we'll continue to research what's available to us. If an account can be created with productivity tools included and some kind of drive space, for document space, that kind of thing, Actually, it may be helpful also because then it becomes a collaboration system, and it may be easier on Victor to be able to point to documents without having to send certain things. You just send a link, click on the link, it opens up that document, whatever. I mean, there's some value in collaboration systems, which is kind of what I do on a daily basis. So sometimes a all-inclusive portal is helpful. Okay. All right. Anything else on this subject? No. Okay, great. And then we have the annual report coming up with the that we send up to the supervisors. Is there anything that you specifically want to transmit or tell the supervisors about the work that we're doing? Yeah.
I feel like we've had some improvements with like the length of our meetings and some processes that we've set up to get things through committees, while also affording petitioners access to the full task force that we should be proud of, and hopefully that can get into the report. I used to attend these meetings before being on the task force, so they used to go a lot later. I think that's good.
Do committee chairs need to get something to you for?
Yeah. Yeah. Do we have a deadline for it? I don't think so. Just annual.
It just states annual.
Yeah. Okay.
I will get a copy of last year's report and distribute it among the chairs.
Okay.
Thank you.
And if we could maybe in 3 or 4 weeks get some items, give you some time to ruminate. If there's anything that you want to highlight to the supervisors, that you maybe things that you want to request from them, like, if we want Victor and DCA Cola to get a raise, we can, or more vacation time, or their own office.
Proposals, guys.
I think those are all like union designated.
I mean, off the top of my head, I do think it would be good to have a city attorney in some of these committee meetings. I think that's come up. I think that I do take Mr. Petrellis's remarks about us having a televised. I think that's really ironic that we're not, and I think that would be great to be addressed.
Or move us to a different room.
Move us to a different room.
Around,
whatever.
This room used to have all the cameras in it.
So that's
when I first was
that's something. And then I'd also just to take things that have been said over and over in public comment that probably should be passed on is that we do have. We are missing a member, and it continues to be an issue. And I think that it is when Mr. Hartz brings it up that it is. He believes it's an unfairness in terms of how a vote comes down. I think that's worth noting.
So just know that I've been working with New America Media and SPJ on that issue because the seat is up for reappointment or it's open, becomes vacant this month. So I can't make sure, but I would like to see New America Media provide a nomination. However they do it, I want to see them do it because I don't want to see this becoming a controversial issue. I think there will be amendments to the Sunshine Ordinance at some point. It needs to be dealt with then, but until then, I think those that are named in it need to be responsible unless they go out of business. I did post kind of a question to DCA Cola earlier today about there is a provision in the ordinance to allow the Board of Supervisors to authorize kind of extending authority to the Sunshine Task Force for, it doesn't specify what that is, but I'm not quite sure that they can authorized to override the ordinance. And so, I think at this point the safest bet is to really encourage them, pressure them, to submit somebody for nomination. It also makes it a little tough on me because, if we end up with a split, you really don't have a tiebreaker with an even number of members. So, and every other commission is an odd number of members. And in Robert's rules, it's always suggested. So So that's kind of my motivation for that. Victor, is there anything else you wanted to maybe from your end, from the business, end?
I'll go through the report and
Okay.
I'll make some suggestions as I read through it.
Okay. DC Acola, is there maybe anything you wanted to highlight from your perspective? Yeah.
I have to compare it to last year's report and see if there's anything that strikes me as that needs to be added.
Okay. Or if you have something inventive,
Yeah.
it's up to you. All right. Let's move on to the next item.
Next on the agenda is item number 12, Administrator's Report, Complaint and Communications. On the tentative hearing schedule, the next meeting of the EOTC is on April the 18th. I just want to find out if there are any conflicts with the members. That would be Chair Wolf, Member Fisher, and Member Eldon.
That's Josh Wolf.
Josh.
What date was that again?
That's April 18th at 3:30.
It's in the attachment in the agenda. It's all listed there.
And I have to look, this way he could just tell me. So it's April 18th is a... time?
That's a 3:30 meeting. I believe it's third Tuesday bi-monthly.
Bi-monthly.
If there are issues,
That's a short, right, at 3:30, we're done by 5:30 or 6.
Make sure we get everything. Maybe you can send us the exact schedule so we can make sure that,
yes, I'll confirm via email and your ability to attend.
Are we having the IT committee on the same day?
I haven't got confirmation from. I proposed the date, but I haven't received confirmation from
Member Wolf and Member Moss is here.
What was the date on it?
April 18th. It'll be after EOT. It's because we can't get rooms
Yeah,
for
no,
other
I'm
days.
trying to remember what it was that.
Yeah.
2 people got up and left, and I got to stay. New people came in. I'm like, how did I get in this?
So I cannot do Tuesday, April 18th, I'm afraid.
Okay. What complaint committee? What time do you guys usually finish? 5:30.
5:30 to 7:30 on the 25th.
Okay. What about earlier that day, Victor?
I believe we can start at 4 o'clock on that day. We have the room starting at 4.
Oh, okay. How about the 25th?
At what time did you say? Like
4
p.m.?
o'clock?
Yeah, I can do that.
Okay. So let's send that out to we'll ping Member Wolf, Josh Wolf.
So
This is
you
the
guys are only gonna be for an hour and a half.
Yeah.
And you can let me know via email if there's anybody you would like to invite.
Yeah. We'll do that. Was there anybody else on the IT ad hoc? Anybody who wants to? Actually, it's an open invitation. If anybody wants to join it, feel free. The more minds, the better. Okay, continue.
Complaint committees, next regular meetings on the 25th at 5:30 to 7:30. The next task force meetings on May the 3rd. I believe that the Compliance and Amendments Committee, I would like to wait for Chair Member Kanata to return before I announce that one. Coming back to hearing schedules. I believe that the Compliance and Amendments Committee would like to cancel and reschedule their May 8th meeting to the May 30th due to the inability of several members to attend on May 8th. I already have made room reservations for 4:30 on May 30th, if the members are agreeable to May 30th.
For May 8th.
Oh, okay, never mind, sorry.
So May 30th, you said.
4:30 is the earliest I can get it.
This is okay. That's fine with me.
Me too.
And we'll likely be hearing the Chan case, I'm guessing, quite possibly.
There was a continued case. That's why we wanted to keep it
Yeah.
in the meet.
We might hear that case.
Oh,
again
yes.
today.
Yeah.
Okay. Yep, that's good.
Moving on to item 2, as you can tell, there was a short surge of complaints submitted. There were 3 of them that I was able to resolve and have withdrawn. That was 1710, 1714, and the last 2 numbers should be 17, not 16. That would be 1720 was withdrawn. Pending complaints. Last month we had 19 pending complaints. This month we have 23 pending complaints. Item 4, this older item, file number 14047, is scheduled before the next EOTC committee meeting for a hearing. And I believe there are 4 complaints pending before compliance amendments that will be scheduled on the May 30th meeting. And I believe file number 16117, the committee has requested that we send out a request for public records regarding the matter to the public library and to the city attorney. That request will be sent as soon as we can clean up the language.
Victor, sorry, just to interrupt you. 16109, is it possible that that won't come before us if, I forget her name now, supplies the documents that we agreed to the last meeting?
She was supposed to look into 4 emails.
Responses to emails, I think it was
and,
4 or 6.
and to provide a response regarding their IT search for documents that were lost.
Yeah.
I don't believe that Mr. Black will agree to withdraw it.
Okay. Worth a try, though. I mean, if she...
Yes, once I receive an official response, I'll forward to Mr. Black and see if he's willing to withdraw. That completes my report.
Okay, great. I just want to, if you don't mind, really quickly to go back to the annual report. I mentioned this before. The ordinance allows the Board of Supervisors to provide some extension of authority. So I was thinking there are certain things that I think might help us. Like nobody comes in here under oath. But if they go before, if there's some inquest, is that the word, before the Board of Supervisors, they could require, I believe they have the authority to require to be a person to be under oath. But I'm just wondering if there's anything like that, like subpoena power. They have subpoena power. They can demand, documents beyond the ordinance in that kind of way. So I'm wondering if there's anything you think that we feel inhibited by or that might help us to, that we might ask for the supervisors to provide us with authority with. That they probably won't, look at us funny, But I'm just thinking if there's anything really functional, it's kind of inhibiting our ability to do certain things, or, would be more helpful, would help reduce number of complaints, or, you don't have to answer right now, but I just want to put it out there that, we can ask for that at any time. Has to be done by ordinance, or the voters have to do it. So I'm not sure what the limitations are as for what the supervisors can provide. The ordinance doesn't necessarily, it's very vague on that, or very open-ended. So, yeah.
I think one thing that might be worth putting in the report is just the fact that we are in communication with the Sunshine, I forgot their exact name, but the body that's reforming the Sunshine Ordinance, led by Richard Nee. And
the San Franciscans for Sunshine.
Just to bring it to their attention that this is something that's going to come up, and we're part of it. We're giving them input, maybe not go as far as saying they have our blessing just yet, just to see what the final product is, but
We're being,
consulted.
it's being reported to us.
Actually, the consulted, they're asking us for input, and I think they came to our compliance and amendments, and we said, please come back to the full, where we can all, and give us some, some documentation to think about and whatnot.
So just a little quick history on this. When the amendments were first drafted, there was how should I say this? There was a proposal made by a supervisor to put a competing set of amendments on the ballot that would have basically stripped the ordinance of all its uniqueness outside of the CPRA and the Brown Act. And so that is a big concern to those folks. That's why they decided to go on their own to put, the ballot initiative on and possibly not come through the board process. But at the same time, the task force has an obligation, if it finds that there are areas of the ordinance that it feels needs to be adjusted or changed, to notify the Board of Supervisors so that they could put something on the ballot to get it changed. And hopefully it's not a weapon, it's a tool, but...
Hasn't that supervisor moved on?
He has.
Lovely.
He has, but there is a replacement.
As there always is.
Right. So, okay. But I just wanted to put that out there, I would be a little cautious, because if we do any kind of work on that, it can be somewhat deemed as making a recommendation, just by fiat. So, all right. Next item.
Next on the agenda is item number 13, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Yes.
I seem to always have future agenda items.
Yes, go for it.
I would like to bring SFPD in here to explain to us their nonsense public records center that they've built, which seems to be...
I agree.
Seems to be in violation of the Sunshine Ordinance, and I would like them to answer for it.
Okay. So do you want this to be a committee of the whole?
I would rather have it come up here than...
That's what I'm saying.
Yeah.
It would be a committee of the whole.
I think that SFPD is of such significance, and what they've done here with this record center is of such significance that if we just do it in our compliance and amendment, we're just going to have to do it twice, because I think it is quite... They have built a really bad system that has things that are troubling to me. So, for example, you file a request with SFPD. They automatically enroll you in their system. And you have to go log in online and create an account.
Anonymous.
You want to file one anonymously, you have to write down the number. And if you lose the number, you have to file your request again. And that's according to their stated policy on here. They've built this online system, and it doesn't seem to be compliant with anything, and I don't know if I should just go and file a complaint and then we deal with it that way, or if we just bring them in here and get them to explain.
So, so they're not even in compliance with the city attorney's guidelines?
They're non-compliant. I don't know where they came up with this.
I think that's have them come in here, but I think people also need to review the system as best as we can. We can request, just a flow chart process from them on paper so everybody can see, what it is beforehand. I just wanted to let you know that I am trying to meet with as many department heads as possible, just to kind of make the introduction and say we're not the big scary monster, hairy monster in the closet. Just to get an idea of what their concerns are at the same time, so that we can address certain things. But it's both department heads and commissions. They're two separate entities that we have issue. It's funny, when I went to the library and I talked to the head librarian, he didn't really have any issues. He wanted to talk about the commission, and I'm like, I'm not here to talk about the commission. I'll talk to the president of the commission if I. He was like, oh, okay, well, you want a cup of coffee? It's like, jelly bean?
Commentary on the
others?
He did, but all he was saying is that, I think we're doing pretty good with them. He's not discounting their, the efficacy of their questions or anything like that. And they're just trying to process everything as best as they can, because I think, he understands that we can't adjudicate on intent, so they have to deal with that. So.
I would. There's other things.
Yeah.
All right. So
Go for it.
So this may not be for a next thing, but I did hear somebody. Was it Kate Patterson who talked about record track that?
Yes.
And if that is something that the city is implementing, I don't know why that hasn't come to us first, or has not been something that's been run by us. So I would like to find out who's spearheading that.
Well, let's quickly ask our administrator, has the clerk gotten any wind
I haven't heard of this. Before.
Okay.
I mean, it's not a bad system. It's the system that Oakland uses, but I mean, it is a significant change.
I have heard there's some testing going on, but I haven't heard of any implementation.
Specific, no names, brand names or anything? Okay.
Yeah. But I mean, it's the sort of thing that if they are going to implement that, it is going to be citywide. We should probably push to get some language on there that explains people's rights to them and what the procedure is.
Yeah. Well, one of the things that we can do, first of all, is find out whose project this is, under whose department, and then demand our involvement in it. I think that's, or better word, request to be involved in it, because I think it would be much more helpful and beneficial, considering we exist. So.
I mean, and there can be benefits to systems like that. My work is working on putting one together right now, or it's like in beta, we're testing it. And what we've seen is that, requests come in and the document has already been deemed public and it has been given to someone else. But then it would sometimes go through this whole process of careful review, even though that careful review already occurred for someone else. And, people were waiting for things that they shouldn't have had to wait for. So there are some benefits for the portal for tracking things that have already been released, and so that people don't have to wait for a careful review to happen. But, of course, we should give input if we can.
Yeah. And the only other thing I was going to raise is what I raised earlier about how we're kind of back to the drawing board about this out-of-office email situation. Maybe compliance and amendments needs to talk to Department of Technology again and be like, your suggestion.
Actually, why don't we discuss it at the IT committee?
All right, that works for me.
Because we'll probably have to do a lot of focus. I mean, DT, I think, finally hired a CTO. Not sure who it is yet, but they've been 2 years rudderless. So that's kind of, what's going on there. And I mean, they are running the full Microsoft enterprise with SharePoint and all that stuff. And I think there's something in there. There's some product that can be module, extension, plug-in, something that could serve a purpose for this.
I mean, if the IDR filter is working for the Arts Commission, then remember Kanata's looking at me because we were just both saying, why can't you do that? Why can't you do that? And he's like, it's unreliable. Why is it unreliable?
Right.
It's just unreliable. So, I mean, if it's working for them, so as long as we're talking about it somewhere, that makes me happy. And that is the last thing I will raise for future
Okay. All right. Anything else for the good of that cause? Anything that you would want the IT committee to look at? Okay. Yes? No? Email me if you got something. Okay.
Oh, sorry.
Yes.
I had one other question, not for the. So I had seen in Victor's administrative report that Member Wolf has a complaint before the complaints committee, and I was wondering if there's anything specific we should know about how to handle such a situation.
Basically, we will recuse him because he's party. So it's kind of an automatic recusal, but we will do it formally, and he will just do his thing as that. And it'll be just a recusal for that one item. And that's it.
President London Breed.
Supervisor London Breed. That's kind of the way it works. Okay. He'll request recusal. We'll decide whether he should be recused or not. It's kind of the standard process. Simple.
Okay.
And that goes for anybody else that wants to bring a complaint forward. Okay. All right. Motion to adjourn.
Second.
Okay. We all in favor?
Aye.
Opposed?